With your permission, mention, Your Lordship. Your Lordship, I am 51 on the list today. The last time it was heard was last August. But we find a lot of interest, and therefore there are 12 more interveners and some 12. More, yes. 12 and 8 are already listed, and some more are coming. I thought it, with your permission, to make a suggestion that if this matter could be considered by a committee of all the people involved, and then a decision made and then brought to this court and then argued, it would be save time, and a matter which has been pending since 1958 should reach a conclusion. It's only a suggestion, Your Lordship. It's a way of also, in my opinion, I'm not presuming, but a way of.
That is the very prayer in the petition.
Yes.
Huh? Yes, yes. That's a prayer of the petition.
So
but
side is,
but each one need not speak in the court about it and have it discussed in a committee.
we would like to be enriched by this.
Yes. It's one way of putting it.
For hearing, any date can be fixed. If the impleading applications have to be allowed, then we'll allow today. What do you think?
My lords, last time the impleading applications were allowed.
Only one or two was allowed.
Please, my lords.
Today we are told that there are 8 more. All are in the sailing in the same boat of Mr. Swami.
Yes.
Yes. So that can
No, some of them are opposing. But some impleading applicants are
All the impleading applicants are opposing, my lords.
opposing.
yes.
Please, my
They're
lords.
not in-
When the state is opposing, my lord.
State is opposing.
Whatever, but or they may be given audience when the matter is heard, whatever, the impleaders
Because we need to file our objections, my lords,
do.
to the main petition.
Then do it, then we'll set down the time.
Unless we are
so that-
impleaded in the matter and the copies are served on us, we cannot do the same. My
Then
lords.
this process, it is a procedural become. Now let it be heard substantially. Learned party in person is every time has to come and then without any substance.
No, last time it was told that we'll be impleaded and the copies will be served on us. Then we will be filing our objections. Copies are not served on us, my lords.
It can be set down in somewhere in the first week of March. 1st or 11th March, we'll do.
First week of March. First week
In
of
the
March.
meantime, on that day, it is understood, subject to, of course, contingencies arises, that will be heard. We would like to have the submissions of both the sides, rather than straightway coming to any conclusion.
Your Lordship.
So what about the impleading applications?
My lords, I'm the impleading applicant, my lord.
You are opposing.
Yes, my lords.
My lord, we have filed our statement of objections. The government has.
State we know.
Even we have filed. Center has filed.
You also filed.
We also filed.
My lords, I think most of the respondents are objecting, my lords. Only the respondent number 11 is supporting the petitioner, my lords. Rest of the impleading applicants who are brought on record as respondents are objecting the petition.
Yes,
So,
yes, we are
substantially it will
opposing.
be the same, my lords.
So some impleaders are supporting and some are.
Only one impleading applicant is supporting, my lord. All the others are opposing.
We don't know where the scale will tilt. 1 or 15 will not matter. But anyway, we're allowing all the applicants.
Yes.
Please, my lord.
Saying that they are the parties interested in the outcome of the petition. So all impleading applications, please give the list. We'll allow in today's date. And the petition. May be
And if all pleadings can be completed by end of February, on 11th March, your lordship can hear and dispose.
So pleadings to be completed before 3rd March.
Please, my lords.
3rd March is fine. Yes, Your Lordship.
The present petition is listed today along with applications filed by the applicants who seek to implead themselves. To stop. Heard learned party in person, Mr. Subramanian Swamy, for the petitioner for some time. Has also learned additional Solicitor General, Mr. Kamath, as well as learned additional government advocate, Srimati Nilofer Akbar. As also the counsels appearing for different parties for some time. In the facts of the case, it is provided that the parties to the proceedings shall complete their pleadings on or before 3rd March 2025. The petition shall be next listed on 11th March.
Obliged, my lord.
We may,
By separate order, all the applications are.
there may not be any more interveners because if only they are opposing us, they're already enough. So they need not have any more.
Even if they are coming, we'll not allow now.
Much obliged.
Thank you very much.
Lords, kindly have to mention a matter.
Yes, from this side. Yes.
Lords, writ appeal against an order of learned single judge, my lords, final judgment. Lord, student sought creation of a transgender quota, where my lords, learned single judge himself, my lords, observed that the writ petition had become infructuous because the student sought admission in 23-24 academic year. Now, my lords, in December 24, 1.5 years after, my lords, that exam had been concluded, the learned single judge, my lords, now directs me to admit the student. This is, my lords, an appeal by the National Law School, and create, my lords, an ad hoc transgender quota, in terms of which, my lords, now the student is knocking on my doors, my lords, seeking admission. I am seeking, my lords, writ appeal to be posted, my lords, against that judgment anytime next week, my lords. Wednesday, if it's convenient. My lords.
12th February.
Lords, could it be on a shorter date? Because the student is now insisting that 2/3 of the year is already over. Student is saying, now admit me into the university. Could it be on 29th, my lords?
7th February.
Lords, in the meanwhile, I apprehend a contempt action against me, my lords, because there's a direction to admit the student.
Contempt will come before us only.
Yes,
You
my lords.
mentioned that appeal is filed and posted on 7th. Yes, next.
Very well.
Maybe first that move before the Honorable. And the
13th February.
urgency in the matter to be listed tomorrow.
No.
Date is given on 6th.
Who has given the date?
This court, Honorable Court, when I moved day before yesterday, it has been listed on 6th
Date of appeal, date in appeal.
February. 6th February.
No. Date is given to what matter? Date is given in which matter?
This matter, this very same matter.
No, preponement by memo is not permitted. You file IA if you want to prepone this. Preponing of a date given by judicial order is not permitted by memo. If you want have some good reasons to prepone the date, file IA. Yes.
Appear for the appellant Malad in WA 1569 of 2024. This is the matter, Malad, pertaining to the Buddha. Your Lordship, Malad, has specifically listed it on Saturday for hearing.
Lords,
Due to some inconvenience, Malad, we will be seeking a short adjournment.
Lords, even I appear in these appeals, my lords. My lords, I'm before your lordships here, my lords. I'm sorry.
Yeah.
My lords. Yeah, my lords, I appear for the other appellant in these appeals. Your lordships had fixed it.
Which
for-
matter?
Pertaining to the Buddha.
That is kept on 25th.
Yes.
25th, the
So
Saturday,
you are mentioning on whose behalf?
on behalf of the appellant.
Appellant, all the appellants,
All the appellants.
in all 3 appeals.
All three.
We have
And
no,
also informed the other side, because all of them are on board.
the government will be there.
We have
The
informed.
government has been intimated, the office of the governor has been intimated, and the 3 private respondents also have been intimated. But we thought we'll just keep your lordships informed in advance. Malad,
That is
because
good.
it's a Saturday.
That is very good. So that we may not read it.
Please, we'll seek an adjournment on Saturday.
So when do you want?
You have to open.
You
Lord,
mention
could
on
we furnish the date on Saturday?
mention on Saturday.
Please,
Mention on Saturday.
very well. Obliged.
Serial number 35 in today's list, my lord.
Serial number?
35 in today's list. I appear for the respondent, my lord. Contempt matter is filed. It's coming up on the 29th, my lord. It may please be connected with the contempt matter.
2 days.
I have moved the memo, serial number 35, I am for the appellant. They have prepared a contempt which is coming up on the
29th. My lord, it may be, kindly be, no prejudice will be caused to them, my lord, just a matter of less than a week, my lord, 29th.
Madam, contempt can be deferred on the ground of filing of appeal.
Please,
Appeal cannot be deferred on the ground of filing of one.
my lord, I'm only saying, my lord,
I have urgency, that is the reason I moved.
my lord, 4 days, 5 days, my lord, 29th, it may, I'll also file an objection to the IA for state,
Let it be called out.
In
We'll see what is.
29th,
You remain present when it is taken up.
please.
We'll see what to do.
My lord, serial number 81, my lord.
We are not refusing your request, but let it be called out. Yes.
But serial number 81, my lord. I seek an adjournment, my lord.
81,
Yes, my lord.
adjournment. When? Then it will go in March, 12th March.
Interim order, my lord. My lord, interim order is there, maybe.
Interim order is there. Then it will come on 18th February.
Much obliged.
My lord,
Interim
serial
order.
number 37, my lords.
Interim order shall continue to open.
Serial number 37, my lords.
67,
37, my lords.
37.
Yes, my lords. I am for the appellant in this matter, my lords. I praise 1 week of accommodation, my lords.
21st February.
Much obliged.
Memo, my lord.
My lord, in W8929, Your Honor have passed an order on 15/1/25. There is a minor error in the order that yourself have passed. So I request memo for being posted, spoken tomorrow.
Two more.
My lord, fresh matter, my lord.
Miller.
Yes, yes, madam.
Serial number.
Yes, madam, yes. Yes,
My lord, in CC number 58/25, madam. Address is that.
refused,
Contempt of court petition.
refused, yes. Yes, madam. You refuse, your memo is refused, mister. Yes,
Against the appellant ban, directing me to hand over possession. However, I still recover 4 crores. They have preferred a contempt which is coming in the first week of February. This will be taken up any date. in-
appeal, this is appeal. 6th of February.
My lord,
It's
it's
a
a tender process is going on, my lord. My matter is.
Yes. No, no.
My lord, writ appeal, my lord.
Yes,
Writ appeal, my lord.
yes.
It's a surface matter, my lord. Surface matter.
Pardon?
Surface matter, my lord.
Is it writ appeal? Writ appeal.
Yes, my lord, please.
What is your?
Urgency is, my lord, the learned judge has given only weeks of time to comply with the order, my lord. Anyway, the time has been lapsed and
What is the order?
to pay the 4 crores, 4 crore of rupees to in within 1 week, my lord.
17th March, 17th February.
My
lord,
my lords, serial number 40, my lords, it's a state appeal. My lords could adjourn it for a week's time, my lords. Some instructions are required, my lords.
My lord, I appear for the respondent, my lord.
7th
They have been informed, my-
7th February.
obliged.
But serial number 48, my lord.
Yes,
It's a contempt matter, my lord. Notice has to be issued to the respondent, my lord. The order of this honorable court has been defied by the
4th
accused
of
person.
March,
Serial number 48, my lords. I seek for some time.
48. What do you want?
I'm for the petitioner, my lord. Some adjournment may be granted, my lord.
Adjournment at the request of learned petitioner, stand over to 10th March.
Grateful. my lords.
Pardon?
In forest matter, it's regarding solid waste disposal. A contract was issued and it is about to expire. It's with respect to Mahabaleshwar city market. And the solid waste management has definitely issued and we have been trying to move this matter and being listed for a
It's
year.
PIL,
No, it's a GM forest.
Green Forest. It can wait up to 13th February, 13th February.
My lord, one submission. In one fact, my lord, in contempt, your lordship directed the respondent accused to comply the matter.
And I was given liberty to move in complaints is not made. They have not made the complaint. Whereas my submission is I pray for the early hearing because the another honorable judge is distribution board of will be only for 1 week. The matter was passed by your lordship and
That is no ground.
this
The court continues, we are nobody.
Please.
As individuals, we are nobody, yes.
The same
That is no ground that somebody is retiring, sorry, yes.
Will be any date may kindly be given.
Will be given,
Please.
not on this ground,
Not
not on
this ground, my lord. But the order I have been given liberty to recall the same. IA is filed. Any date may kindly be granted, my lord. Your lordship may kindly approve.
If the bench is required to be constituted, then no date can be given.
Please.
New bench is required to be constituted, you will move the register judiciary.
Please. I am much obliged.
My lord.
I apologize.
My lord,
Yes, Mr.
my lord, fresh matter.
Yes.
Contempt petition, my lord, the matter is very urgent, my lord. I am one of the government contractor, my lord, wherein the government is called for tenders, my lord. Without obeying the order of this honorable court, I have already succeeded in WP, my lord. This honorable court has directed the
Is
government.
it a contempt petition or appeal?
This is a contempt petition, my lord.
Contempt
This
petition,
matter is very urgent, my lord.
17th February.
My lord, this is fresh petition, my lord, the PA, my lord. The respondent constructed the building on the Rajakalave. I am fighting against the,
It will come once you remove the office.
my lord, my lord.
Once you remove the office, it will be listed. within-
Office objection, there is no office objection.
There is no point in mention. It will be listed within 1 week. Yes.
Yes, Lord, on serial number 65, my lord, I am the complainant. Serial number 65, my lord.
65.
Please, my lord, I am the complainant, my lord. The order of the learned Singh is compliant. Request to be dropped the contempt proceedings, my lord. I am prepared with them.
You are complainant.
I am the complainant, my lord, representing Mr. A. Sampath. 65, my lord.
65.
Order is
591. Learned advocate Mr. So and so appearing for learned advocate Mr. Sampath A. For the complainant stated before the court that the order under contempt is complied with, and it was further stated by submitting withdrawal memo dated 23/1/25 on record that the instructions are received from the complainant to withdraw the contempt petition. The contempt petition is dismissed as withdrawn.
Please, oblige.
Serial number 63. The required to file objection or inform the other side.
Yes.
With serial number 94 listed today, there is an urgency in the matter. It's a
Yes.
writ appeal.
Yes.
There's garnishee orders have been initiated against us, issued to against us. Hence, there's an urgency. May I request it to be taken up at 2:30, my lord?
What is the urgency?
The urgency is that the ESI department, I have challenged the order. In pursuance to the order of the issued by the ESI department, they have issued garnishee orders against me, and they have directed my banker to release a sum of 5.5 crores.
Tomorrow? Tomorrow?
No, it is listed today. May I request for 2:30?
Can it be taken up tomorrow? Tomorrow.
My lord,
You
because the orders may be passed today, that is why. They may release the amounts today, hence my request.
They are going to release the amount today.
The bank is forced to release the amounts. That is the reason why. The ESI department is forcing the
And it
bank.
can wait for 1 day. Let us go
It
through
is
the.
listed, that is by, the matter is listed today, 94. May I request-
Tomorrow will again be listed.
My lord, I'll take my chance today, my lord.
No, we are not aware of the subject matter. So let it be.
94, my lord.
And this is on delay also, 118 days.
No, 94, there's no delay, my lord.
There is.
I'm sorry, the delay, yes, insofar as the writ petition is, yes, my lord, from the date of the, hence because of the,
Delay in writ appeal, then notice will have.
because
to-
I had filed a review petition also, and
That
the
is all
review
right,
petition.
whatever may the ground of delay, but there is a delay of 118.
I'll take my chance today. I'll convince. my
There is no
lord.
question of taking chance. If there is a delay, we'll issue notice in delay application first. We can't advert to the main appeal.
May I seek, I'll convince my lord on that matter, my lord. May I request, my lord?
You can convince.
Because there is on merits also I have a case, but the problem is that the bank is being.
It is not our business. Unless condone the delay, we will not take up the appeal. We can't take up.
My lord, tomorrow in the end, top of the list.
No, notice can go to in the delay application today.
I'll take out notice on the counsel who is appearing for them in the writ petition, and matter may be listed on next week, because there is an urgency.
Notice returnable, notice in.
I'll take
IA
it on the
number
counsel.
24 returnable.
I'll take it on the counsel who appeared for them in the writ petition, my lord, because, and it can be taken up next week, because the bank is initiating due to release that amount. That is the urgency, my lord. I'll deposit that amount before this honorable court. I'm
4th of February. In addition to normal mode of service, learned advocate for the appellant applicant is permitted to serve a copy of the delay conversion application as well as the appeal in advance to learned advocate who appeared before learned single judge.
before the learned
We
single
have
judge.
this.
My lord, the date may kindly be fixed, my lord.
4th February.
4th of February.
Office objection shall be removed before the next,
Council submission.
which shall be full stop. Removal of office objection shall be the condition precedent for taking up the matter, including the delay conversion application. Unless office objection removed, will not take. Yes. Don't crop up the artificial urgency. And there is nothing, no matter is not ready in terms of delay and office objection. Yes.
63, pray for adjournment.
60?
63.
63.
From the other side. Need to file objection.
What is that? 63?
Contempt.
Contempt petition. When do you want?
Not,
19th of February.
Serial number 52 for the petitioner, my lord, I seek for a short accommodation.
52.
Yes.
I appear for the respondent in this case.
I request
We have
the
filed the
28th of February. All day, 28th of February.
Appear for complaint.
Obliged.
Complaint into order. Contempt. Preliminary hearing.
Pardon? Posting,
Post memo.
3rd March.
Any other mention through VC, sir? And permission. So fresh content matters. Still number 1, so Janardhan G. Janardhan G.
Learned single judge order is not complied with. Lecture, page 9, the order. And there is the,
This
thereafter.
2018
What
order.
happened is, they have stated the reason that writ appeal 2475 is pending. Then they sought for some clarification. The college thereafter, my lord, on 22/12/2022 has clarified the same and saying that that order will not come in the way of complying with the order and requested them to grant the pay scale. Still,
We have
thereafter,
considered it, my lords,
we
and
issued a legal notice also, bringing all the clarification and explain the delay by filing IA, my lord.
You can't explain the delay.
And
It is not the section
But
5.
the reason for filing,
Limitation.
that the cause of action for them to consider has been
What you
Hold
stated.
we have
because of the-
considered it, my lords. Our affidavit is also ready. Yes, with respect to pay band,
If it is considered.
please, my lord, so one of the complainant has been granted one pay band, the other is not entitled because of the eligibility criteria, my lords, it's been considered.
For those who are not considered, but I will.
So nothing survived.
Those who are which one in respect of which the second one, not if it is not considered, not it is not entitled, not I will liberty may be granted. Not consider filing.
In this contempt petition filed on 20th for 24th, contempt of court is alleged in respect of the directions issued by learned single judge in order passed as back as on 5th of September 2018. In any view, paragraph, compliance affidavit is filed, which is placed on record by learned additional government leader, Ms. Pramodini Kishan, to submit that the directions of learned single judge are taken care of, and one of the applicant is also granted the payment, whereas the other is held to be not eligible
Yes.
in view of the criteria to be applied. Full stop.
First,
In view of the
first complaints, I think they have granted some relief.
same.
So for second one is
Any of
concerned,
the same,
they have not considered, they said they are not entitled. Let me challenge that liberty.
whatever, any of the, we are not taking cognizance, any of the same, comma, without going into the aspect of maintainability of the belated contempt petition, comma, it is disposed of.
Still number two, to Vivekolda.
Lordship, the order on the contempt is at page 170, wherein a mandamus was filed and the assistant commissioner was mandated to complete the proceedings.
Not completed,
No,
notice returnable on 5th of March.
Still number three, Leela P. Devadiga.
I appeal for the complainant in this matter. The writ petition was prepared by the complainant in 15605. An order was passed on 5/3/2022. It is placed in Annexure C, giving a direction to the respondents to consider the complainant's plea of regularization as a one-time measure. This order was then placed in writ appeal 403 of 2022. An order was passed, upholding the single judge's order on 23rd of May 2023. On 23/7/2024, on the complainants have been.
So you are supposed, you are required to file within 1 year from the date of.
Please, we had given representation, on false, they had not regularized me, they had not regularized me, but they had assured me that they will be regularizing me. On 23/7/2024, Annexure G, page number 136, they have, the respondent university has issued a representation, to Kodagu University to appoint me, I had to be appointed regularized in Mangalore University. Now giving me false hope, still date they had kept my representation at bay to consider me consider my regularization. On 23/7/2024, they give a representation to another university to consider my regularization at my appointment.
Representation will not extend the period. What do you want? You can have any other remedy, including for which we are not advised.
But the delays of 1 or 2 days,
the direction was given by a single judge in order dated 5th March 2022, was inter-alia to direct the
pass over the matter,
respondent university.
Kindly pass over the matter. My senior will come.
You are now more than senior. Respondent university to consider the case of the petitioners for regularization as one-time measure in view of the decision in the writ petition number 51342 of 16 in connected matters. No time limit is prescribed paragraph for the compliance of the above direction. Furthermore, as the order was passed on 5th March 22 and the contempt petition came to be filed on 12th December 2024, the bar contained in section 20 of the Contempt of Court Act 1971 would operate inasmuch as the petitioner complainant was supposed to file the contempt petition within 1 year from the date of within 1 year. Full stop. In the above view, the contempt petition is not entertained. However, it is open for the petitioner to avail and pursue other remedies for enforcement of the direction of learned single judge regarding regularization in accordance with
Still number 4.
In this, I appear for the complainant, my lord. On 3/6/24 annexure G, an order has been passed directing the accused to enter the revenue entries in the name of the complainants, my lord. A representation is made by annexure E on 21/6/24. A legal notice has also issued on 23/10/24. Till today, it has not been complied.
4th March notice.
Much obliged.
Number 5. GS Prasanna Kumar.
Millard. Actually, the non-compliance of the order, the accused had undertaken to vacate the premises within 1 year. However, he do not vacate, and further he files an application for extension of time after 1 year. And when the court insisted on having the rent paid, that time he withdraws that application also as not pressed. He had undertaken by way of affidavit 1 year back to vacate the premises. But the documents.
Notice returnable on. Learned advocate, the petition, so and so.
Notice and
Files memo
the daily order.
accompanying certain documents which is taken in the records. Notice returnable on. February 28th.
The PL matters, number 6. Ashwin.
Your lordships, the page number 67 of the PIL may be looked into, your lordships. The annexure E. The petitioners are greatly concerned about the project initiated by the respondent number 1 along with the national highway. In order to reduce the traffic, they've identified 3 black spots, your lordships. Black spots are accident spots, and technical term used by them in their DPR. Annexure E may be looked into, your lordships. The current accident spots. Now, this is located in the district of Dakshina Kannada, and 3 have been identified. Can be, its exclamatory mark has been, can be seen. KPT Junction, Padua High School Junction, and Nantur Junction. Now, the proposed project of the respondent number 1 is from the KPT Junction, your lordships, to Padua High School Junction. In order to eradicate these black spots, accidental spots, they are digging from KPT Junction to Padua High School with a meter of 5.5 meters, your lordships. And thereafter, the digging continues from Padua High School Junction to Nantur Junction. Now, it involves 5.5 meter of digging, your lordships, and there are high chances of water being stored, and there are no hydrology tests conducted by the respondent 1 in their DPR, your lordships. Now, what we are proposing is, your lordships, from the Kuntikan flyover, in the same image, annexure E1, there is a identification as Kuntikan flyover, where there already exists a flyover to Pumpwell Junction. There also is another flyover. So if a elevated flyover is being conducted from Kuntikan flyover to Pumpwell Junction, with a deviation at Nantur Junction, then these problems can be eradicated, your lordships. Accordingly, a representation had been filed, had been presented by the petitioner herein, and which was not being answered by the respondent, your lordships. So annexure E2 is the extension of the project, your lordships. Now, Nantur Junction, there's another accident spot at Nantur Junction, which goes to Kulshekar Kamla flyover, Kaikamba flyover. So there are already existing flyovers. So the act of the respondent to have 2 underpasses when there are already flyovers, rather than continuing the existing flyover to another flyover, is totally unacceptable, your lordships. And there are a lot of trees in this passage. Now, if an elevated flyover is proposed and looked into, these trees can be saved. Now, there might be, there involves a question of expert opinion on this, your lordships, whether this is practically possible. I have presented volume 2, your lordships, of the writ petition, and I have conducted an independent expert opinion on these projects, that elevated project, your lordship. And my expert opinion is presented at page number 525, annexure N.
Volume 2.
volume 2, page 525. Volume 2, page 525 is an expert opinion from a architect, your lordships, wherein the proposed elevated highway was consulted, and the highlighted portion, the relevant portion I may be permitted to read, your lordships, which is in annexure M, which are bulleted points. Present use of national highway through the growing city of Mangalore is questionable in long term. It has to be decongested with another bypass beyond the city limits. Paragraph before that, your lordship, they have suggested elevated highway from Kuntikan to Pumpwell as an alternative solution. Studied the proposal of an elevated highway at length, and it is technically feasible. Already there are flyovers at Kuntikan and Pumpwell, and connecting these 2 points by an elevated highway is more practical. At page number 524. Thereafter, your lordship, at page number 525 to page number 520, page number 525 to 530 is an independent survey being conducted with the annexure P1 and annexure P2 of the chart of the survey of the chart of the highway, your lordships, where Kuntikan flyover and Pumpwell flyover can be connected through a elevated highway at annexure P1 and annexure P2. So with the proposed elevated highway, your lordships, more trees can be saved, and it's practically feasible as well. Unfortunately, there are highways being constructed previously, your lordship, the infamous Pumpwell highway.
Lord learned, sorry, we don't interfere in all these technical things.
In fact, my lord, in a April 24 judgment, your lordships have held
15th April.
15-4.
You have got
No, these are, your lordships have held
to the learned.
matters pertaining to road design alignment are in the domain of the executive.
Your lordships have filed a representation. Now, the recent development is that the MP, the member of parliament of the district of Dakshina Kannada, had approached the union minister of roads and highways, your lordships.
Very good.
Now, there what was proposed was there were certain technical flaws, including even in this project. Now,
You also go to the honorable minister.
your lordship, now there is my humble submission is that my representation may be considered, your lordships, and public opinion may also be considered.
Pursue representation, we have no objection after withdrawing the petition. If you want to pursue representation, we have no objection.
We already submitted, your lordship. They just need to look into and substantiate the same.
We have seen from your prayer that you have made a representation.
Yes, your lordships. Now, the particular project has been temporarily stalled, your lordships, for reasons best known to them. Now, what needs to be considered is, your lordship, whether this particular elevated highway could be considered or not, because even in their DPR, there are no explorations of that subject. There should be a reason given by them why an elevated highway cannot be considered. So all that has not been looked into.
This is all in executive domain. We are not the right forum to interject.
Your lordship, since there are a lot of trees being involved, because the same is also not in compliance with the National Green Highway Policy, your lordships. Now, if the project itself, as your lordships has rightfully noted, since it doesn't come on the executive domain, the point of view of the National Green Highway Policy 2015, that has also not been complied, your lordships. There are numerous number of trees that have been cut in the same stretch of project, which have not been translocated and transplanted as per the policy. Now, the respondents are required to answer this question, your lordship, which comes entirely in this domain, your lordships. That needs to be considered and needs to be looked into, your lordships. The respondents may kindly be, notices may be issued, your lordships, with regard to that. As far as the National Green Highway compliance is concerned.
Our uniting order, and we'll pass the order. Yes, decide. Choice is yours.
Your lordships.
Your choice. Exercise your choice. Two options are available.
There is a domain also, your lordship.
Lord
as well.
learned advocate, Mr. So and so for the
I'll withdraw, your lordships.
learned advocate seeks permission to withdraw the present public interest petition dismissed as withdrawn.
Grateful.
Bill number 7.
For the petitioner, there's a petition in public interest. Lordship may kindly see the prayer in the petition at page number 28. This is a petition which concerns the interplay of the provisions of the Information Technology Act and the new Bharatiya Sakshi Adhiniyam. Lordship may kindly take page 28 of the petition. The relief that I have sought for is a direction against the respondent to designate adequate number of examiners/experts under section 79A of the Information Technology Act pertaining to the state of Karnataka in a time-bound manner. Now, your lordships are aware, insofar as the older Indian Evidence Act is concerned, section 65 capital B of the older Indian Evidence Act pertain to admissibility of electronic evidence. Lordships are also aware by virtue of two judgments of the Honorable Supreme Court, that is in Anwar PV and Arjun Panditrao Kotkar, the Honorable Supreme Court was of the view that that is a mandatory provision and no document in electronic form can be admitted in evidence without the mandate of section 65B. Now, if your lordship, if I may take your lordship to the equivalent of the section 65B in the new act, I have annexed the act also.
Yes, Saksha Adhiniyam.
Please, I have annexed the act also to the petition for your lordship's consideration. Please.
Let us.
Lordship may kindly come to page number 64.
64.
Please.
65.
64, your lordships have it. Section 63, admissibility of electronic records. Notwithstanding anything contained in this adhiniyam, any information contained in an electronic record which is printed on paper, stored, recorded, or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device or otherwise stored, recorded, or copied in any electronic form, shall be deemed to also be a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in any proceedings without further proof of production of the original as evidence of any contents of the original or any fact stated therein of which direct evidence would be admissible. Now, if your lordship, if I were to advert your lordship's attention to the concerned section, which is section 63 clause 4 in the bottom of the very page. 63 clause 4 lordship may kindly see, in any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things shall be submitted along with the electronic record at each instance where it is being submitted for admission, namely, so on and so forth. I will skip that, your lordship. Lordship may now come to the last part. And purporting to be signed by a person in charge of the computer or communication device or the management of relevant activities, lordship may now kindly mark this, and an expert shall be evidence of any matter stated in the certificate. And for the purpose of this subsection, it shall be sufficient for a matter to be stated to the best of knowledge, so on and so forth. So what I'm emphasizing upon is this notion called as an expert. Now, if expert, of course, is not defined in the section. However, if your lordship were to now kindly come, in fact, if I may just advert your lordship's attention to the schedule that is mentioned in this particular provision. Can I just take your lordship to page 89 of the petition? Page 89 of the petition, if I may just. This is the schedule that is mentioned in section 63 clause 4. If I may take your lordship's attention to page 89.
Schedule.
The schedule, please.
Schedule to the act itself.
Schedule in the act itself. In fact, for your lordship's convenience, I have annexed the entire act to the petition itself.
Here there is no act. Schedule to which act?
Schedule to the BSA, the Bharatiya Sakshi Adhiniyam. That is in fact there in the petition itself. I have annexed the whole act to the petition.
Why there is no schedule here in this book? No schedule.
Act Sakshi Adhiniyam.
Schedule in.
It may be in the last, your lordship.
Incomplete publication. Schedule 63 4C.
Please,
Yes.
lordship may now, there is part A which is mentioned. Lordship may now come to part B. Part B is to be filled by the expert. Part B is to be filled by the expert. So therefore, the pith and substance is, whenever I am adducing evidence before a court of law, which is in electronic form, I will have to annex a certificate in the form of an affidavit, which now, as per the Sakshi Adhiniyam, comprises the certificate to be signed and attested by the expert. Now that in fact brings me to the definition of what an expert is. If I may just take your lordship to page 59 of the petition, which is section 39, which talks about what an expert is. Page 59. Lordship may kindly see section 39, subsection 2. If I may just read for Lordship's convenience. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79 capital A of the Information Technology Act 2000 is a relevant fact.
Where you are reading?
Your lordship, page number 59, subsection 2.
Section 2 you are reading.
Please. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79 capital A of the Information Technology Act is a relevant fact. So now section 79 capital A, I'll take your lordships to, which defines, which is really the pith and substance of this petition. Lordship may kindly come to page 169 of the petition. 169. This is the Information Technology Act, page 169. Lordship may kindly see section 79 capital A at the bottom. Bottom, section 79 capital A. Central government to notify the examiner of electronic evidence. The central government may, for the purposes of providing expert opinion on electronic form evidence before any court or any authority, specify by notification in the official gazette any department, body or agency of the central government or the state government as an examiner of electronic evidence. Therefore, the remit is with the respondent herein to designate these examiners / experts, which are adverted to under the Bharatiya Sakshi Adhiniyam for a particular state. Now, insofar as Karnataka is concerned, if I may just bring your lordship's attention to annexure G, which is at page 250. Insofar as the state of Karnataka is concerned, there is only one examiner that has been notified for the entire state.
But examiner must have been notified under section 79 itself.
Please, and now that
to discharge the duties under the Sakshi Adhiniyam.
And that notification your lordship finds at annexure G, page 250. 250 of the petition. Your lordship may kindly see. This is the notification dated 4th September 2018. In exercise of the powers conferred by section 79A of the Information Technology Act, central government hereby notifies State Forensic Science Laboratory, Madiwala, Bengaluru, under Directorate of Forensic Science, Karnataka, Police Department as examiner of electronic evidence within India with the following scope, so and so. So my grievance before your lordship is this. For the entire state of Karnataka, which comprises so many districts, there is only one examiner which has been designated. Now my respectful submission is, with the introduction of the Bharatiya Sakshi Adhiniyam under section 63(4), it is a mandatory provision, as I explained to your lordship, by virtue of the two honorable Supreme Court judgments, which in fact I'll just place for your lordship's kind consideration. Now, if that provision were to be a mandatory provision, tomorrow when I were to lead evidence before any court of law, I will have to compulsorily take the expert certification or the certificate. Now in far-flung districts, it would be extremely difficult merely for the purpose of getting the certificate to come all the way to Madiwala and then produce it before a court of law. What I'm espousing before your lordship has in fact the view taken by the Madras High Court. I just point that out to your lordship.
No, these experts will be notified by the central government
by the central government under section 79 capital A.
for each state differently.
Page number 48, 49, 50 is not there.
Sorry, Your Lordship.
For each state different,
For each state,
differently.
in fact, Your Lordship, I'm grateful for that, for
This
Your Lordship's question.
notification at page 250 is in relation to state of Karnataka.
Yes, 250 is only insofar as Karnataka is concerned. In fact, Your Lordship,
So
would
for each state, such notification must be there.
please, in fact, Your Lordship, to flip to the previous page, 248.
Yes.
Now, this is a list of all the examiners for the entire country that has been designated under 79 capital A. Now, there are 16 such examiners that the Union of India has designated. So therefore, insofar as the state of Karnataka is concerned, there is only one such examiner. At this stage, I'll just request Your Lordship to kindly take that memo which I passed on, which has the judgment of the Honorable Madras High Court on the very same aspect. I'll just point out to that, Your Lordship. If Your Lordship has that memo of the Madras High Court, judgment of the Honorable Madras High Court. Lordship may kindly come to page 108. Your Lordship has 108, if I may be permitted to just point out. Lordship may kindly take page 109. This is a recent judgment of the Honorable Madras High Court. Page 109, second unnumbered paragraph. The effect of the above provision is that filing of the certificate is mandatory along with the electronic record. Certificate is to be signed by the person in charge of the computer system and an expert. Subsection itself refers to the schedule annexed to the act, which is in two parts, part A and part B. Part A is to be filled by the party and part B is to be filled by the expert. Section 39 of the BSA deals with opinions of experts. Then Your Lordship may now come to the bottom of the page. In light of the above three provisions, namely section 63, section 39 of the BSA and section 79 of the Information Technology Act, one can conclude that a person desirous of relying on any electronic record as a document in evidence must submit a certificate at the time of filing the electronic record. The certificate must be in two parts, part A and part B. Part B must be filled by the expert notified under section 79 of the IT Act. Para 6. It is admitted by the central government that only a handful of entities have been notified till date as experts under section 79A of the Act. It is surprising to note that no expert has been notified in the state of Tamil Nadu. It is beyond dispute that Tamil Nadu has good IT infrastructure and skilled manpower. Since BSA has already come into force, very soon there will be need for certificates under section 63(4) of the BSA for securing admission of electronic records. If experts are not available in Tamil Nadu, that would result in denial of right of access to justice, which is a fundamental right. I therefore direct the second respondent to expeditiously notify sufficient number of persons/bodies/entities as experts in the state of Tamil Nadu. The number to be notified will have to be commensurate with the possible demand. It would be advisable to have such experts in each district in Tamil Nadu. This exercise of assessment and notification shall be carried out within a period of 3 months from the date of receipt of a copy of this order. Since the position as on date is that meeting the statutory requirement is not possible of compliance, the learned amicus wanted me to read down the section, so that may not be relevant. So therefore,
We'll take notice. Requires consent.
I do not want to interject. I have just one request, Your Lordship. I have sought for an interim relief. I know, I understand it is a public interest litigation. Lordship may kindly take a look at my interim relief sought for at page number 29. 29 of the petition. Pending the disposal of the instant writ petition, is most humbly prayed that this honorable court may be pleased to issue a direction to all subordinate courts and tribunals falling within the jurisdiction of this honorable court to not insist upon the compliance with section 63(4) only insofar as the requirement to obtain a certificate duly signed by an expert in terms of schedule of the BSA is concerned, and thereby save the validity. I understand.
This interim prayer takes up the beauty of your petition.
I understand.
How can you break this? The court should not.
I wanted to-
not to follow a law.
All I'm saying is, now what may happen is, if I were to adduce evidence in trial, and if I don't have the certificate, trials may go on and it may be subject of appeal or revision later on. So therefore, all I'm saying is, insofar as part A of section 63 and the schedule is concerned, I will comply with it. That is insofar as the old regime is concerned. Insofar as this expert is concerned, I am seeking for some relaxation, because otherwise it will scuttle trials, is my respectful submission.
Let the affected party then come. I mean, if there is some affected party facing any difficulty, he'll come. The petitioner has raised a cause, we'll get instructions on the main relief. As far as interim relief is concerned,
No.
if there is some party who is affected, he'll approach your lordship.
I leave it to your lordships.
The petitioner heard learned advocate Mr. So and so, the petitioner and learned additional Solicitor General Mr. Arvind Kamath, who appeared along with learned additional
Deputy
Deputy Solicitor General Mr. Shanti Bhushan, upon service of copy of the present petition in advance. The petitioner happens to be a practicing advocate since 2013 at city of
The conditional city, yeah.
Bengaluru,
If you are
who has filed this public interest petition seeking direction against the respondent Union of India to designate adequate number of examiners, public experts under section 79 capital A of the Information Technology Act 2000
meeting
pertaining to state of Karnataka. Learned advocate for the petitioner. Sorry, the petition.
Sorry, your
Learned
lordship.
advocate, the petitioner. Where is your this Madras judgment?
It is by virtue of a memo that I have filed today. Your lordship has it. It is at page number 108.
Learned advocate for the petitioner took the court through the provisions of section 63, in particular subsection 4 thereof of read with section 39. Into bracket 2. As also section 169. 169.
79 capital A of the IT Act, Information.
1 second.
I'm sorry.
P92 read with part 2 of the schedule provided under section 63(4) into bracket C of the Bharatiya Sakshya Adhiniyam 2023 to submit that section 63 into bracket 4 of the Adhiniyam It is 63-4 contempt, it's giving of certificate. 63-4.
63-4 is the provision. that-
Contemplates certification of electronic evidence
Please, 63,
by an expert.
please.
Full stop.
Expert is defined in 17.
Reading the said requirement under the Bharatiya Saksha Adhiniyam in interaction with section 79 of the
29 capital A.
Information Technology Act 2000. Which inter-alia provides that the central government shall notify examiner of electronic evidence. It was submitted that having regard to the requirement to comply with the provisions of section 63, including subsection 4 thereof, in the proceedings of trial, in the criminal cases, large number of evidence in the nature of electronic evidence would be required to be considered by the court, which are in turn to be certified by the experts and the examiners as contemplated in the aforesaid provisions. Full stop. And attention of the court was invited to not where is that notification?
Page number 250, page number
169.
250. The notification. Pointing an
attention of the court was invited to notification dated 4th September 2018, issued by the Ministry of Electronics and Information Technology, Government of India, in exercise of powers under section 79 of the Information Technology Act 2000, whereby the central government has notified the State Forensic Science Laboratory, Madiwala, Bengaluru, under the Directorate of Forensic Sciences, Karnataka, Police Department, as the examiner of electronic evidence within India.
In the state of Karnataka.
Where is that in the state of Karnataka?
Your Lordship may kindly see.
Within India.
Bengaluru.
Doesn't appear to be.
This may be.
It appears to be for whole of the India.
No, this appears only insofar as Karnataka is concerned.
Anyway, India, full stop. It was submitted that only one agency is designated and notified by the aforesaid notification to act as an expert for the certification of the electronic evidence which may be produced in court of law in the trial. To further submit that Pardon. Palace. Scheme ಮಾಡಿದ್ದಾರೆ. Scheme is implemented or not ಗೊತ್ತಿಲ್ಲ. Evidence. In the drag, full stop. The notification indicates that it applies to entire country and only one agency, namely the State Forensic Science Laboratory, Bengaluru. Designated. In any case, comma, it is the submission of the it is, in any case, it is submitted that only one agency is designated in the state of Karnataka, which will be a too inadequate provision to deal with number of cases wherein the electronic evidences will be required to be certified. It is in this context paragraph that the prayer in the present petition is made to designate adequate number of examiners and experts under section 79 of the Information Technology Act. Full stop. The issue raised, the cause sought to be espoused. The cause sought to be espoused. Prima facie bears importance to compliance of the swift, the speedy compliance, speedy conduct of the 898 criminal trials by supplying the adequate experts for certifying the electronic evidence, and thus raises an issue of public interest. Paragraph notice returnable on 20th February.
Great.
Before next date, the respondent shall file a reply and respond to the cause.
I'm grateful.
We are not taking note of this Madras.
Sorry, Your Lordship.
Madras judgment, we are not referring to in the judgment.
I'll leave it to you.
Or we'll add it in a line, so that.
Please, please.
How it is more.
Because identical situation observation.
We'll add those observations.
Please, please. I'm grateful.
Yes, number 8.
My lords, I appear for the petitioners in this matter, my lords. The public interest litigation, my lords may kindly recollect this matter.
Respond number 516, ma'am.
This is a petition, my lord, seeking direction to protect the school property which belongs to the second respondent. The subject matter, my lords, is way back in the year 1956, my lords, one Pattabhiram Rao, who will have vast extents of land, he will execute a gift deed with respect to 3 survey numbers, my lords. That is survey number 92 for an extent of 30 gun.
IA is filed.
IA is for vacating stay, my lords.
By you?
By the respondent, my lords.
Filed by 516, ma'am.
Who are 5 and 6?
Now, after obtaining the interim order, the petition number 1 made a representation to the PDO as annexed in my objections, compilation objection document.
Where is the interim order?
Interim order, my lords, it's dated.
Passed by this bench?
Allowed on 30th January 2024.
Restraining my movement, madam. Respond number 5 and 6 movement has been restrained.
Not to interfere or put up any construction over the land bearing survey number 97/3 for an extent of 30 hectares. The reason is, my lords, because the said 30.
Second part, R. Restraining the ಆದ್ಮೇಲೆ next ಇರ್ಬೇಕಲ್ಲ.
Or put up any construction.
Not to interfere ಇರ್ತಕ್ಕಂಥದ್ದು. Because we are in peaceful possession and enjoyment of the property. My movement has been restricted.
This property, my lords, absolutely belongs to the
Because
school.
we are already adjudicated, the subject matter of this matter already adjudicated before the competent civil court, and also judgment has been passed. Against the judgment, the respond number, the defendant in the OS suit is a preferred RA. The same is pending for adjudication.
My
Though
lord,
the
the
petition number
suit
3,
itself is
though
flawed.
the petition number 3 is a witness to the said OS proceedings, he categorically deposed that the property has been utilized, not utilized by the government, is utilized by the defendants in the subject matter in OS suit. But in the said proceedings, this property belongs to the government. His first petition is none other than his brother-in-law of the defendant Lakshma Kamal. Now, the suppressing all this fact, after defeated the suit in original proceedings, they filed the writ petition by giving the color of public interest litigation because it's a purely personal interest litigation. Though the property involved is the 3 properties involved in the gift deed, but they're only restricted only 30 guntas.
Because that
So
is the.
we'll hear the public interest petition itself
Please.
on,
Now, interim order may be vacated because
No, my lord. I oppose the vacating of the interim order. The writ petition has to
has
be
not
allowed.
filed any
I'm
objection.
relying,
Even petition also not filed any objection.
no, it's all right.
They
This,
can tell
this,
from
this can be
1956.
argued. There's no necessity for filing a statement.
1956.
My lord, they are
that's-
relying on a sale deed where they haven't traced the document, traced.
There's
the
no title flow.
itself. I'm relying on a decision of the Supreme Court. My lord may hear us.
this is PIL.
Yes, my lord. Please, my lord.
Writ
PIL.
petition has to be allowed.
Suppressing the civil fact because
That's
those
the scheduled property,
The
my lord.
suit itself was
Kindly.
not flawed. It couldn't have been filed. I don't know how such a judgment has been passed by the trial court.
my lordship, as per the version of the petitioner,
The
the
property, my lord, is
1956, the 1956.
My lord
the
may
gift deed
hear us,
exactly
my
have
lord.
been
The date
executed.
may be fixed, my lord may hear us.
No, today's the date has been fixed. Ma'am.
Very well. Now, let him argue. I'm ready.
Today date has been fixed for hearing. Ma'am.
Of which matter?
The last date, ma'am. Last date of hearing, this honorable lordship is directed to argue the matter today.
Who has directed? You can't dictate the court for hearing a matter particular date.
Sorry,
The
ma'am.
present interim application is not adverted to and shall be taken up along with the hearing of the public interest litigation, which shall be listed for hearing on 29th of January at 2:30.
Obligement.
please, madam.
No insistence for any matter for hearing, Mr. Counsel.
Sorry, my lord. Last time, this honorable lordship has directed to both the parties to hear the matter.
Unless
That
we
is-
hear, there is no direction. It is under our discretion to hear or not. You
Please.
can't say that hear the matter right now and this today itself. That itself is objectionable.
Please.
As far as this court is concerned. Yes, next.
Please, madam.
So come on 29th and we'll complete the.
Yes, my lord.
You-
I'm ready.
you put it in. Yes, madam.
The green bench matters, seal number 9.
My lord,
Trustee
in this,
Mahesh,
the last date of
appearing for
hearing, I
petitioner, my
made a
lord.
submission that an incomplete copy had been given to me and I had made a request for a complete copy that hasn't been supplied, my lord.
What is it?
Serial number,
9.
yes,
It is incomplete.
incomplete. Please take it, sir. Give me your copy.
I'll provide my lordship, but it may kindly be taken up
What do you want? Copy.
next week.
Yes, my lord, it's incomplete. There is no prayer in that. I don't know what the prayer is. It's incomplete.
I will provide my lordship, it may kindly be taken up next week.
So you want no objection certificate from whom?
My lordship, NOC has to be issued, my lordship, by the revenue authorities. A request has been sent on 28 December 2023 via annexure N, my lordship. Annexure N. A request has been made, my lordship, by the Deputy Director, Office of the Deputy Director, my lordship. Deputy Commissioner and the third respondent needs to be issued a NOC, my lordship, Revenue Department. Already earlier, my lordship, this honorable court directed by order dated
So you want no objection from this mining department or?
Revenue Department.
Or revenue department?
Revenue Department.
And execution of lease deed, no.
No, there is no, it is not yet executed lease deed, my lordship. Forest Department already submitted their NOC, my lordship, for granting the quarrying lease. But Revenue Department, my lordship, still even after lapse of 1 year, my lordship, they are not submitted.
Learned advocate for the petitioner shall furnish entire set of the petition to learned additional government advocate, Srimati Nilofer Akbar, who shall in turn take instruction.
Next week, my lordship, because within 2 years
My lord,
Will take instruction.
I'll take instructions. It's
And the-
incomplete.
The copy shall be supplied within 2 days. The
Today,
petition may be
during
listed-
course of the day, I
petition
will-
May be listed on 10th February.
Obliged.
Number 10, Mr. Mahendra SS.
I appear for the petitioner.
Lord, serial number 10,
Yes,
13 to 21 and 23.
13 to 21 and 23, all are same.
All are same. Lord, similar matter, this honorable court was pleased to grant interim order.
Yes, yes. I will not dispute it.
Subject to deposit of 7.5. In 3 matters, it has been passed.
My lord, time is, has to be fixed, my lord, and the last date, I think, due to oversight, it has not been mentioned. 7.5 lakhs to be deposited. On an earlier occasion, my lord had fixed it for as 6 weeks. But in this, it is not fixed. Time is not fixed. Paragraph.
So this is really makes us state of petitions all of a sudden. And we doubt whether we have passed a correct order or not.
No, no, I can. My lord,
No, original
time.
petition was
My lord, that was.
much earlier than this.
Yes, yes, that is, my lord, 30.
So the amount in each petition will be different. Lord, claim will be.
Yes, yes, each one is different, but my lord has.
Your lordship
restricted
was
it
pleased to
7.5.
order for uniform deposit, not in all the matters. 7.5.
My lord,
This is similar to one which your lordship was passed on 10th January 2025.
My lord, in WP 30419 of 24, my lord, on 13th November 2024, my lord was pleased to fix the time within which the amount had to be deposited. In this order, my lord, the time is not fixed. So my lord may fix 6 weeks' time, as was done in 1311.
Which order it is not fixed?
My lord, this order, 10/1/2025.
Is 32357.
Yes, 32357. After paragraph 5, my lord will see it.
In this matter also, we have deposit order.
That is omitted. It is omitted.
We have already deposited it.
Already deposited.
Yes, in this matter also we have.
My lord, I just have to give, I think, the mathematical calculations.
It can go with common order.
Yes, please.
Serial number 9,
Serial number 10,
12 to 21.
13 to 21.
So
Serial number 10, 13 to 21 and 23.
12 is different.
12 is different.
So 10, 13 to 21 and 23.
Please.
My lord, time may be fixed, my lord. for deposit of the amount.
It was undisputedly stated by learned advocates for the petitioners in each of the petition. Mr. S.S. Mahani, that the set of facts and the issues involved in all the above petitions are similar to one involved in writ petition number 32116 or 2024, which was dealt with at the admission stage as per order dated 20th 12/24, is also writ petition number 32357 or 2024, which was subjected to interim order dated 10/1/25 while issuing notice. Full stop. The date of order in each petition paragraph and the demand of penalty amount involved in each of the present petitions are tabularized as under then made table, serial number, then writ petition number, then date of the impugned order and the amount of penalty claimed. In view that this court has issued notice in the earlier identical petitions, similar petitions, there has been notice in all the petitions returnable on when? Same date? 24th of February 2024.
Lord, may I seek dispensation for issuance of notice for respondent 5, Lord. I am filing a memo for R5. I am seeking dispensation.
Dispensation, why?
Because he is a formal party, no relief is sought against him.
Notice returnable 24/2/25 in each of the petition. Full stop. At this stage, learned advocate for the petitioner files a memo seeking to delete disposable file.
Dispense.
The delete. Dispense with. Seeking to dispense with the notice to disposable file at this stage. Full stop. In view of the memo which is taken on the record, comma, the notice shall go to all the respondents except respondent 5. Paragraph.
All the other respondents are state authorities. No? The
Learned,
government advocates.
Additional government advocates with the Nilofer Akbar accepts notice on behalf of the respondents, except respondent 5. Paragraph. Interim relief was pressed. Paragraph. Interim relief was pressed on the same lines as is granted in the aforementioned similar petitions. In that view, it is directed that the respondent shall desist from taking any coercive steps pursuant to the impugned notices in each case, provided each of the petitioner deposits rupees 7,50,000 towards the amount demanded before the authority concerned within a period of 4 weeks from today.
Yes, Madam. Well, Lord, at page 118,
Well, to
annexure C3, it doesn't pertain to the petitioner in this writ petition, my lord.
Not able to then show to Swami or to.
Obliged.
Yes, ma'am. That's all.
My lord, at page 118, annexure C3, it doesn't pertain to the petitioner.
Can you show what is the error in the impugned orders?
Lord, the error is that, Lord, in the year 2018, the government of Karnataka issued 4 circulars withdrawing the demand notices issued for the year 18-19. There are 4 circulars which I have produced at annexure UV W and X. Those 4 circulars withdraws all these demand notices. Despite of the same lot, the state government issued demanding all this exorbitant amount. Second aspect of the matter is not, this drone survey has not been conducted at all. There is no report at all. Without there being any report, they say they have conducted drone survey by one thematic infotech, which is not a empaneled drone survey organization. It has to be empaneled with the government of Karnataka. It is an unauthorized organization. On these grounds, Lord.
Only these 2 grounds. So you mean to say?
And this is, one more aspect of the matter is, these demands are raised only for the year 2018-19. It is humanly impossible to excavate such an amount of mineral within a period of 12 months. This lease was executed in the year 2014. No due certificate has been issued. We have filed, the audit reports are issued for the year 2014-15, 15-16, 16-17, 17-18. We have paid, we have cleared all the dues. Only in the year, just because some complaint is made, this survey has been undertaken. And I am told that the mineral has been calculated right from 1972 till 2019. That is how this 20 crores, 30 crores. For example, one of the cases, the area is only 5 guntas. In that case, 6 crores has been demanded for a year. It is humanly impossible to excavate.
It was submitted in the very first.
Yes.
My lord, he chooses not to avail of an opportunity to come before the concerned authority and make his submissions. My lord, the conclusions may be seen.
On that line.
If you can redo it, I think we can remand the matter
Take a
back. Just
call.
get instructions.
My lord, I'll take a call on that because the secretary has considered each and every contention that has been raised before him. And he's arrived at a conclusion at page 76. Now, since this is falling before my lords, my lord, I will put it across to the government and make my submission on the 24th.
At the same time, there are 35 leases in 32 acres. 35 leases in 32 acres, Lord. Therefore, on the suggestion of the government, we have processed for amalgamation of all these leases. Government has passed an order to that effect. To amalgamate all these leases, quarry plan has been submitted, EC has been submitted, our lease is in currency. Despite of that, Lord, they have stopped our leases.
So we can keep it on 27th instead of 24th.
No, my lord, may I have it on 24th? I just have to take a call that has fallen from my lords.
Only 2 days after, 27th.
Very well, very well.
27th of this month.
No.
February, okay.
Obliged, ma'am.
In some way, the issues raised are to be addressed by you.
My lord, that is being raised before my lords now. What was raised, my lord, in the form of a column, my lord, the secretary has addressed it. But this is being, my lord, new grounds raised. Since it has fallen from my lords, then let him urge these grounds before the secretary. That will be considered, my lord. Looked into and considered.
May I make one submission? Let them produce the report of thematics on the basis of which these notices have been issued. There is no report at all. How can they issue notices, demand notices? Let them produce on the next date of hearing.
What notification?
The report of the survey,
my lord,
based on which they have issued all these notices. There is no report at all.
My lord, in one breath, they agree for redoing. In another breath, they say, produce the survey. They have to take a decision as to what they want. they can ask this very same query before the secretary, who will be able to, my lord, having
No,
the
we
entire
are asking
records.
we are questioning the
entire
action of the
records.
government. They have issued a demand notice mentioning that thematic Infotech has conducted drone survey and submitted a report. All that we are asking is, let them produce the report before this honorable court based on the basis, based on which they have issued these notices.
My lord, why wasn't this query put before the secretary when the matter was being argued? This is all afterthought.
No, probably because you are mentioning that there is a report.
My lord, yes, they could have asked for the report. They could have asked for the report from the
It
secretary.
is for them to produce.
No, unless you ask, we will not produce. Why should we produce? You ask and you get.
You are saying that they are inviting survey by themselves.
No, my lord, not that. Survey had been conducted at the time of conducting of the survey. An opportunity was given, but they did not avail. That is what is observed by the secretary. Now, since it has fallen from my lords that if we could redo it, my lord, before the secretary, my lord, the report will be there. They can get a copy of the report and urge all the contentions, what are being urged.
That is all they want.
My lord, I'll take instructions with regard to that.
This cell number 11.
We have
Channa Mallikarjun.
Here, my lord, there are two prayers, one challenging the 2019 notification, and my lord, Mandam is directing the respondents to prepare an exit plan scheme. My lord, this, if your lordships recall, Kapatguda Wildlife Sanctuary, my lord, your lordships had passed an order that is coming within 1 kilometer, which your lordship's order was confirmed by the Honorable Supreme Court also. Page number, your lordship sees page number 251. Your lordship's order. Not because upfront I must bring it to your lordship's notice what has happened earlier. My lord's got Annexure J, page 250. Subsequently, my lord, your lordship's orders have been confirmed by the Honorable Supreme Court at Annexure K, page 282. In fact, my lord, a similar writ which was filed, there, my lord, notice was issued and there was my lord, here I'm not seeking for that interim order. There was an interim order that was continued by your lordship's, my lord, that is listed at serial number 49 today. My lord, now, all that we are now seeking is for, my lord, that notification and, my lord, the exit plan. And that too, my lord, only in so far as block number 4. My lord, the conservation reserve in the year 2017, my lord, which was declared as 178 square kilometers. Subsequently, my lord, there was a writ petition filed challenging that. This honorable court, my lord, upheld the 2017 notification. And just prior to that, my lord, the government, my lord, issues a notification. In 2019, just before the judgment is, just 10 days prior to the judgment, knowing very well that the court is considering, they include a lot of other areas. So that is one of the prayers, my lord. The second prayer is that an exit plan. In fact, my lord, the Honorable Supreme Court in Godavarman case, my lord, where such applications are coming up on a regular basis, in Sariska Wildlife Sanctuary, my lord, which is in Rajasthan, closer to Delhi. My lord, there it appears, my lord, that they have said as to what are you doing for the exit plan.
Lord, because here we are, my lord, carrying on mining and stone crushing activities based on a lease that has been granted. So, my lord, there is no violation of any of the conditions that, my lord, we had argued before your lordships on that. So, my lord, that is not there. So, it is not that we have come in illegally or anything. My lord, legally we have and we have that right. So, we are not.
Your prayer is based on that our decision?
My lord, the prayer on the basis that the first prayer is, my lord, that
modify the boundary of the wildlife sanctuary.
My lord, the central government has to take a call on that first.
How come this prayer you made? On what basis that you want the modification boundary? We do not know what are the.
And a positive direction that too.
my lord, may I make
So
this?
this statement or prayer or claim that modify the boundary of the wildlife sanctuary is based on what?
My lord, based on what happened, my lord, 2017, that if your lordship sees, that is at Annexure E. My lord, this was the.
Our judgment has no relevance to this.
No. What I'm submitting is this. 2017, my lord, this was declared as a reserve, conservation reserve in 2017. That was, my lord, 178 square kilometers. 178 square kilometers, my lord, that was passed, my lord. And in that, these areas have been subsequently included in the year 2019.
It is your
notification.
Or union.
My lord,
2019.
we have to, my lord, the central government has to take a call. It is thereafter, my lord, we take a call.
But
And-
central government is doing.
Yes, central government.
For They're under Forest Act.
Yes.
Under
My lord, yes, they have to take a call.
In fact, my lord, in the connected matter 49, my lord, there, my lord, the matter, my lord, was listed, notice was issued, my lord, and my lord, they were directed to file objections. The state government, my lord, 3 to 4 times it had come up before your lordships. There also, my lord, objections have not been filed. My lord, if the objections are filed, my lord, at the earliest, both the matters could be, my lord, clubbed, and your lordship may fix any date, my lord, and that day, my lord, the matters could be disposed of.
For union.
Please, I take notice for respondent number 1, my lords, and I seek.
My lord, it's coming
weeks'
up
time.
for the first time
Seek
today, my
instruction.
lord.
See, with regard to your first prayer.
Yes.
It is dependent on the forest cover.
Beg your pardon? Forest?
The area
Yes.
to be declared as reserve forest is dependent on the existing forest cover. There is no question of it purely in the administrative domain.
No, my lord, what happens here is, as your lordship said, this was not the forest area. My lord, they'll have to declare it. I can understand, my lord, if we were doing anything in a forest area, my lord, we would not have. It is on the patta land, my lord, that is an indisputable fact. They, my lord, 178 square kilometers, my lord, they declared in the year 2017, which was challenged, my lord, by certain other the licensees.
And that has been upheld.
That has been, and there, my lord, they had filed objections, the state government saying that we have done a survey, we have looked into whether the medicinal plants and all those things, and this is the area that is required. Then what they do, my lord, is when this Honorable High Court, my lord, upholds the 2017 notification, by the time, my lord, the order is passed by this Honorable Court, they, my lord, go ahead and again issue a notification, again including certain other areas of land. My lord, and saying that these are again, this will be under the, they give a declaration under section 26A. So that's a declaration of area as a sanctuary. So, my lord, that even under 18, my lord, they'll have to again hear all the necessary parties and do that. My lord, we are not against the environment, and my lords have already, my lord, with regard to 1 kilometer, my lord, our activities have been stopped now. My lord's orders, my lord, have already been confirmed with the Honorable Supreme Court. My lord, there is no quarrel with regard to that. Our only thing, my lord, was there, our second prayer also, if your lordship sees. My lord, now what happens is, in all these matters also, my lord, even what the Honorable Supreme Court has said, that wherever these, the mining, my lord, activities are going on or wherever, my lord, that it should be done in a phased manner, my lord, because we have invested, my lord, crores of rupees have been invested. So many people are working with us. My lord, so, and this is not a lease, my lord, because lease, my lord, this Honorable Court, my lord, it has been already held that we have not violated any of the conditions, my lord, of the minor mineral, the lease condition, my lord. So my lease, there is no issue to that. The lease gets only suspended only on the ground that this comes within 1 kilometer of Kapatguda. My lord, that we came before this Honorable Court. My lord, this Honorable Court dismissed our petition, saying that within 1 kilometer you cannot do. That, my lord, we went to the Honorable Supreme Court. The Honorable Supreme Court confirmed the order passed by your lordships. Now my prayer is, my lord, it's not on that issue at all. Whether this could have been come, that is a first prayer. Second prayer, my lord, is that they should have some exit plan, my lord, which is their content, my lord, that they have to look into that. In fact, very recently, my lord, the Honorable Supreme Court in Sariska Wildlife Sanctuary, there, my lord, it appears, my lord, that I'm not sure of what orders, that some kind of an exit plan or something, my lord, who have been there, my lord, because ultimately, my lord, we have also invested, we are doing. So there must be something for us also in that, my lord, how we.
By making prayer number 2.
Yes, ma'am.
You want to wriggle out from the 1 kilometer restriction. By providing that set, direct the respondent to frame a scheme till the rights within the 1 kilometer area. That is not for the state.
Yes, my lord, and even this direction, the first prayer, a
My lord,
positive
that is,
direction.
my lord, because if they don't, my lord, do that, my lord, we cannot be one day straight away shut off and, my lord, asked to leave, my lord.
You
That
have to
is,
shut off in view of the our decision confirmed by the Supreme Court. Once you are within 1 kilometer,
Yes.
there's no question of frame any project or scheme.
Yes, yeah.
no, my lord, that, my lord, I'm not on that at all, my lord. That your lordships have made it clear. My lord, I am now, there is no further thing for me on that. My lord, I am not seeking for, my lord, either, I've not even sought for any interim order in this, my lord. If your lordship sees, I've not sought for any interim order on, with regard to my thing has been stopped. My lord, I have no issues with that, my lord, now. My thing has been stopped by your lordship's order. I'm not getting into that at all, my lord. My lord, even I am for that environment, my lord. My lord, what I'm submitting is this, my lord. In the other matter also 49, my lord, where notices have been issued, my lord, and they have been directed to file their objections. This and that could be, my lord, clubbed. And any date, my lord, your lordship may fix a date, my lord. On that date, your lordship may hear us and dispose of the matter.
My lord, can these prayers be entertained, my lord?
What is 49?
My lord, serial number 49, my lord, that is with regard to the stone crushers. There, my lord, similar. There, what happened was, there, my lord, there was, the lease was terminated. After your lordship's order, my lord, the issue before your lordships in the writ petition, my lord, which the petitioners here, there, my lord, it was with regard to suspension of the license. So, pursuant to the order passed by your lordships, my lord, there, they terminate the lease, my lord, without giving any opportunity.
Identical prayers.
Yes, ma'am.
Identical word.
Yes, ma'am. Their identical prayer, but there an interim order was that they should not, my lord, terminate without issuing any notice to us. So here, my lord, they have not terminated our lease till today. They only suspended, my lord, our license, not terminated. Here they went ahead and terminated.
My lord, that interim order was taken before the vacation bench, my lord.
That we are, my lord, there also we are not, my lord, they have not given us, we are not doing anything, my lord. There nothing is happening there.
That's how the interim order came to be passed. Only the phrase, the writ of certiorari is missing here.
And if your, my lord, if your lordships also were to consider section 26A and 18, my lord, wildlife sanctuary, my lord, if your lordships takes the Wildlife Protection Act 1972, section 18, declaration of sanctuary. Lord, this provision may to some extent answer your lordship's query, my lord, subject to what your lordships have to say.
So serial number 49 also comes within that 1 kilometer radius.
Yes. That also, my lord, is similar.
We can, today is what? We can take up tomorrow at 2:30. Both the petitions.
Lord, may I seek for some time, my lord? We'll also just look into that, or a week's time, my lord, your lordship. Any date, my lord? But because if, may I only request your lordship, my lord, that objections, my lord, if they are called for, my lord, it would make it a little clear, my lord. That is the only request to your lordship.
What is the interim order operating in this 49?
49, my lord, with regard to the termination.
What term?
My lord, because the license, the lease thing which was granted, without hearing us, my lord, they terminated. In the present case where your lordships, my lord, dismissed our writ petition, there, my lord, it was only on the ground of suspension. Here, my lord, where your lordships dismissed our writ petition, there, my lord, till today, my lord, the thing has not been terminated. They have been suspended on the ground of 1 kilometer thing. There, my lord, they went ahead pursuant to your lordship's order. They went ahead and, my lord,
The license is terminated on the ground that you are within the periphery.
Yes. My lord, look, that is true, my lord. There is no. Lord, that interim order, my lord, is of no consequence in that matter, my lord, because we have not been able to do anything on that place. So, my lord, that your lordship may not even. But we may not really press for the continuation of that interim order, my lord. Your lordship may ask them to file objections, and after a week's time, your lordship may hear this matter and dispose it of.
You are not insisting for interim order.
The
49.
Lord, it is there to continue, but my lord, we are not doing anything, my lord. But if that becomes a, my lord, a thing for us, my lord, then otherwise, my lord, if it is there to continue, my lord, otherwise.
My lord, let the Pollution Control Board be also made a party in serial number 49 because crusher unit is being operated and my lord, pollution is bound to be there.
Even crusher units are permitted within the 1 kilometer.
Yes, my lord, and he can, my
Not
lord.
just, not just quarry.
Yes.
Including crusher unit.
Yes.
Today is what date?
23rd.
27th now. 27th at 2:30, not further.
Oblige me.
We'll take up the matter.
My lord, 27th, I'm in Dharwad, my lord. 29th, my lord. 29th.
We'll come to Dharwad.
I'm sorry, my lord. My lord, 29th, my lord, only 2 days.
Oh, like 29th, but we'll complete because this has to be pressed out in light of the Supreme Court.
Yes.
Not that we will not hear you, but on 29th.
Lord, ultimately, my lord, we are also for the environment and everything, my lord. We can't go against the.
To be listed at 2:30 on 29 for preemptory hearing.
Obliged.
For both matters, this 13 and 49, common order.
Obliged.
For reading.
This number 12.
I appear for the petitioner. This matter, the challenge is to Lord, cancellation of grant notification of quarry lease by the respondent authority. Annexure H Lord, page number 100 is the notification. Translation is at 103. Lord, through this notification, quarry lease for a period of 5 years has been granted on 1/1/2013. And the stipulation was that, Lord, within 90 days, the applicant shall get the quarry lease executed in his favor. However, due to his ill-health, Lord, he could not do it. And then Annexure J, the competent authority, Lord, passed this order, recalling the notification. Thereafter, Lord, we have filed revision as per Annexure K before the revisional authority. That came to be dismissed. Now, Lord, by the virtue of amendment, to the Karnataka Minor Mineral Concession Rules, which came into force from 17th March 2023. The state government revived even the applications pending, rejected applications were revived by the virtue of 2023 amendment. And one more important development after filing this writ petition was, there was an amendment to, further amendment to the Karnataka Minor Mineral Concession Rules on 30/12/2024. Wherein, Lord, wherever these notifications were, Lord, cancelled or recalled, the applicant can approach the revisional authority within 90 days from the date of this notification.
And this Annexure J note.
Lord, this amendment.
Amendment. What does it say?
Lord, kindly take
A copy of the notification.
the Rule 18.
This is only 2nd January.
Yes, Lord.
Sir, can I have a copy?
Rule 18, I think. Later. Rule 18, please, Lord. In the said rules of Rule 18, may I read this? In 2, Lord, if the period of notification has expired, before commencement of these rules, the lessee or licensee shall apply revision application as mentioned in clause 1 within 90 days from the date of commencement of these rules. Here is a case, my lord, exactly similar, wherein may I read the
This will apply to, this will apply to which existing leases or also to those who are, also to those leases?
here is a notification, my lord, for grant of quarry lease. I made an application that was processed. Ultimately, my lord, notification in GL has been granted. The quarry lease, in fact, has been granted in favor of my client by the virtue of this notification.
Because of your non-compliance, it is cancelled.
It was, the stipulation was within 90 days, I should get the lease deed executed in my favor. My lord, in Gujarat Potteries case, Supreme Court, Honorable Supreme Court clearly held, once the notification has been my lord, published, the right accrues on the leaseholder. It is only a formal execution of lease deed that was pending. Not by the virtue of this notification now.
Take instance. Notice returnable on.
A chart date may be fixed, my lord, because it is a stipulation here. Within
19
90.
These notification, my lord may see the notification produced by my friend. It's dated 30/12/2024. My lord, they shall come into force from the date of their publication in the official gazette. Now, annexure A has been passed on 7th November 2024.
7/11/20.
Yes, 7/11, it was passed. And by the virtue of this amendment, my lord, the notification which was expired, in those cases, a provision is provided.
Read it.
Please, my lord, may I? Rule 18. In sub-rule, in the said rules, in Rule 18, 1, in sub-rule 1, for the proviso, the following shall be substituted, namely, provided 1. On receipt of revision application in Form RV from the grantee of quarry lease or license within a period of 90 days from the date of deemed revocation of grant notification to the commissioner or director in case of specified minor mineral and Rule 31 ZC, or jurisdictional director or joint director in the case of non-specified, this is non-specified mineral, except Rule 31 ZC, may extend the period of execution of quarry lease or license deed on satisfaction that such delay is entirely for the reason beyond the control of the grantee.
Here, what is the delay?
The reason is not, he was not well, Lord. He fell ill. Within 90 days, he could not get the.
So this communication is of 2015.
Which communication? This?
No, Lord,
Oh, Lord,
this
this
grant
is
was of the year 2013. 13. Within 90 days, he could not get the quarry lease executed. Therefore, this notification was revoked in the year 2015. 15. Right. Thereafter, we filed a revision before the revisional authority also.
You filed?
Yes.
It is pending.
It was dismissed. Now I am seeking, Lord, shelter under this.
When it was dismissed?
This was dismissed, Lord, on 30th May 2019.
And even then 5 years.
Thereafter, Lord, 23 amendment came into picture. In 23 amendment,
Take
even
and,
the,
my lord, I'll take notice and I'll assist my lord.
20.
Lord, my submission is, if I am
20th.
provided to, Lord, if I am with the liberty to approach the revisional authority under this provision, Lord, this may be disposed of.
I don't need to take it.
Hope that your learned friend says same. On the never.
No, no, on the basis of the rule, I am.
5 years. I leave it to my lord. I'm not committing to my friend.
Then why you are file a petition? You could have straightway gone there. Under this amended rule 18.
Yes.
Lord, after filing of my petition, this came into existence.
The filing of it. That option is open, but let she have his own.
Yeah, then Lord, a short date will be granted. Short date. so that
17th
let them-
February. 17th February.
My lord, for me to take instruction. He intends to file a revision.
We may pass that order on
No,
the
I
same-
leave it to my lord. Yes, yes. I'll get the instructions.
You take instruction.
Very well. I'm obliged.
You just look into this up.
Yes, yes.
To be listed at 2:30. On 17th, on 18th.
Obliged.
18th February.
Still number 22.
In this matter, Lord, illegal suspension of Lord quarry lease. The quarry lease was suspended without any authority of law. It is squarely covered by the judgment of this honorable court, Lord.
Today you hijacked our board.
Lord?
You hijacked our board.
I'm sorry. Because all the matters, Lord, it was not listed before this honorable.
You are welcome. This in lighter way. Yes. Everywhere we say that SS Mahendra SS. Yes. What is this?
Lord, only one provision under the Karnataka minor mineral concession
But
rules.
what is the challenge? Let us see.
The challenge is annexure AM, Lord, wherein, Lord, the competent authority has suspended my quarry lease in anticipation of a survey. It is unheard of, Lord. This order was passed merely on the allegation made by somebody who has vested interest. And legally executed quarry lease has came to be suspended by this order. I have prepared a short synopsis also, Lord. It's squarely covered under, Lord, this judgment. Lord, para 8 is relevant. May I read that? Para 8. After extracting Lord 8K in para 7. In legislation, para 8 is in legislation, which provides for grant of license. If there is a power to cancel the license, it is possible to argue that in absence of specific power to suspend the license, such a course could be adopted by the authorities pending the decision on the show cause notice issued to show cause why the license should not be cancelled. In this case, not even a show cause notice has been issued. But in the said rules of 1994, there is a specific provision which empowers the authority to suspend the quarrying operation on the basis of specified grounds provided therein. The said grounds are provided in sub-rule 2 of Rule 8K of the said rules. When there is a specific power to pass an order of suspension in the rules 1994, The power has to be exercised in accordance with the concerned rule and no other manner. As provided in sub-rule 2 of Rule 8K, the Deputy Director of or Senior Geologist gets jurisdiction to pass an order of suspension of quarrying operations if it is found that it is not being carried in accordance with the quarrying plan or simplified quarrying plan referred in sub-rule 1 of Rule 8K of rules. Sub-rule 2 provides for exercise of power to suspend the quarrying operation if the quarrying operations are not carried out as per the quarrying plan referred in sub-rule 1. Coming to the impugned order, there are reasons recorded in the operative portion of order dated 22nd August 2019, but there is no reason recorded that the petitioner has not carried out quarrying operation in accordance with the quarrying plan or simplified quarrying plan as per sub-rule 1 of 8K.
So this judgment says that the suspension can be only on the ground provided in the.
Provided in the rule.
Here
is a case, my lord.
You are saying that in the anticipation of the survey, they have.
In the anticipation of a survey. And my quarrying operation has been stopped.
My lord, please take.
Yes.
They have visited the spot. Come to your page number 21 and 22.
Report is also submitted.
They have visited.
Visited the spot. See, the allegation is you are granted a portion of the land. And another portion of the land was granted in favor of a particular person for agricultural purposes.
Yes.
Which is adjacent to your land. And you have gone ahead and done the quarrying activities on your land as well as in that particular
No, that
land.
is not correct.
That is the allegation made. That may
My
not be
lord,
correct.
Allegation.
Also, my lord may take paragraphs. My lord,
Let me
7,
complete
9,
my submission.
Not based
petition.
on any contingent action. It is based on some already. complete-
Yes, she has encroached because.
No, it is incorrect, my lord. No, may make a submission. The merger has been conducted. There's no doubt about it. Merger has been conducted. In the merger, it is clearly stated that this particular may take your lordship to the merger.
No. Now we are going to issue some notice or what for finally?
No, my submission is, Lord, quarrying operation has been suspended. Quarrying operation is suspended, not under 8K. There is no other provision. Even assuming that they found I have conducted quarrying outside my quarrying area, they have to say, look here, you have violated quarrying plan. In the order, it is not mentioned so. In the order, it is clearly mentioned that in anticipation of a survey.
My lord, please take paragraph. My lord, please take. My lord, please take paragraph 7, 9, and 10 of the writ petition, my lord. He himself admits that it is granted to a person belonging to a scheduled caste person, and he has entered into an agreement to sell. Some dispute must have arisen.
That is altogether a different thing.
Approached and he has mind.
My lord, one should not mislead the court by saying something.
No,
I have pleaded. I have pleaded the fact before the court.
I'm not misleading. He is misleading.
May make a
The straight face.
May make a submission, Lord. In para 6.7, what I have stated is the complainant entered into an agreement for registered agreement for sale with the petitioner. In order to stall that transaction, he made a complaint. That is nothing to do with the quarrying area.
Then why did he aver it, my lord? Then why did he aver it?
For this reason, there is a motive behind the complaint.
No, there is no motive. Please.
Are you arguing on behalf of the complainant or the state government?
I appear for the state government.
Then you are arguing on behalf of the complainant.
Don't mislead the court. You aver and then you put the blame on me.
Take the facts clear, Lord, because I have prepared a synopsis. Vilash may kindly take the synopsis, Lord. It is only one page. Because legally executed quarry has been stalled. Vilash may kindly see. Annexure A to Annexure B to H, my lord, demonstrates petitioner's compliance with all legal formalities, including application, joint inspection, no objection certificates, environment clearance, and proper execution of quarry lease. Then, my lord, Annexure J to P illustrate the baseless and frivolous nature of complaint against the petitioner, as well as malified intention behind the action of certain individuals, that is, Mr. Mutturaju, involved in obstructing petitioner's legal business. Lord, the petitioner is seeking relief against the illegal suspension of quarry lease by the respondent number 3 to restore the lawful operation. Lord, here before suspending, there is no notice issued. There is a violation of principles of natural justice. Then lack of authority. The competent authority cannot suspend the lease unless it attracts 8K2. This impugned order, patently it is illegal, Lord. It has passed without authority of law. Then, Lord, submission against no allegation of violation of quarry plan in the impugned order. Then, Lord, suspension is not supported by law. The order is based on.
There is a violation of the plan because you extended the area.
No, Lord. Even in the major, it is not stated. I'll make it clear.
That we are not here to appreciate that. You go there, we'll permit you to go before the.
May I draw your lordship's attention? Kindly peruse the margin draw. What is stated in the margin? In the margin, it is not stated that I have encroached. The lordship may kindly see. I'll take your lordship to the margin. '81 to '84. The last may kindly peruse. '84 is the relevant portion.
They have illegally included agricultural lands allotted to Dalit family. Very clear.
Blood. I'll read, Lord.
More than clear than what is stated in the order.
Blood. May I read, Lord?
Page 80. They have illegally included agricultural
Alleged.
allotted to
It
Dalit
is allegation, Lord.
to their mining activity and carrying out the unauthorized stone quarrying.
That is the allegation.
Krishna and Rajanna, sons of late so and so, requested to return their land so and so, it is so and so. There no identifiable mark of the original land. Digging large pits unlawfully.
That's the complaint, no? That is the complaint.
Maybe.
Complaint.
Where is Major?
Major is 84, please, no?
So these are the allegations. 84.
Allegations are that, and Major is in 84. May I read the last paragraph? As per the site inspection, the complainant was asked to visit KM Humbegoda as shown the area of quarry lease, so and so. The complainant has shown the said portion of the grant overlap with the area of quarry lease, number so and so. But earlier in the year 2018, mining leases were sanctioned in the said area. Hence, in view of the above background, we who were present at the place informed that action should be taken according to the rules and that we will submit the documents to the office. The undersigned read affirmed these and signed the contents of Lord. The translation is not that happy, Lord. I'll read the Kannada version also. In the Kannada version, it is clearly stated. May I read the Kannada version, Lord, for your lordships. In the para 2, it is clearly stated, Lord. There is a mining area like the place where the leaseholder came to Humbegoda is mining, and no agriculture has ever been cultivated, and the said area has lost its original character. geographically, and there is no survey landmarks in the said area, and there is no durasta conducted. This is important. There is no durasta conducted by the survey department, and no new survey number has been assigned. It is a Gomal land, Lord. Hence, in order to take action, the authorities of the sanctioned record to be verified. After bifurcation, that is, PODI has to be conducted. Without PODI, they cannot ascertain which is the exact area.
Now what action, if you are right, then what is the next action? Cancellation of the.
Yes, my lord, yes, yes.
My lord, now,
My lord, all other procedures have to be followed before, my lord, cancellation is issued.
my lord, now it is suspended, my lord. Legally executed release, and that too in anticipation. Lord, your lordship may kindly see in the impugned order, what they say is, till we conduct further survey, we suspend.
It is not in anticipation.
Yes, my lord, in the impugned order, your lordship may kindly see in 23, page number.
It's not properly worded. They have visited your spot, they have conducted a survey and they have found
Lord,
that,
they have powers only under 8K2. If there is, see, they have to suspend under 8K2. There is no other provision.
Which is that provision? Let us see.
Please. In the judgment itself, Lord, it is extracted. Para 7, please. Para 7 of the judgment, which I have produced, Lord.
Judgment?
Yes, sir. I am relying on Lord D. Shankar's case. No, that's not part of the book, which now I have passed on, Lord, to your lordship.
Paragraph?
Paragraph 7. Rule 8K of the said rules of 1994 reads thus. 8K, quarrying operation to be in accordance with the quarrying plan or simplified quarrying plan. Every holder of the lease license, working permissions and tender shall carry out quarrying operation in accordance with the approved quarrying plan, simplified quarrying plan, with such condition as may have been imposed under sub-rule 2 of Rule 8G, or with such modification, if any, as approved under sub-rule 3 of Rule 8G.
So they are trying to suggest that you have transgressed beyond your quarry area.
And it's based on, my lord, the complaints by the owners. It is not as if that we have gone and we have done it.
My lord,
Further verify by drone survey and after hearing you.
my lord, para 10 may be.
They have not concluded.
Para 10 may kindly be
Only suspended.
of the same judgment, para 10.
Yes.
Coming to the impugned order, there are reasons recorded in operative portion of so and so, but there is no reason recorded that petitioner has not carried out quarrying operation in accordance with quarrying plan, simplified quarrying plan, as per sub-rule 1 of Rule 8K of the said rules. It is well settled that if law provides that a particular thing has to be done in a particular manner, it must be done in that manner only and not in no other manner. As the power to suspend the quarrying operation is confined to the ground set out in sub-rule 2 of 8K of the said rules of 1994, in the absence of specific ground taken on the basis of material that the petitioner has not carried out quarrying operation in accordance with the quarrying plan or simplified quarrying plan, the action of suspension of license granted to the petitioner cannot be sustained. Here also, it's a similar case, Lord.
Heard learned advocate Mr. S.S. Mahendra for the petitioner and learned additional government advocate Srimati Neela Akbar for the respondent state and its authorities who appear to assist the court upon service of copy of the petition in advance. By invoking the jurisdiction of this court under Article 226 of the Constitution, the petitioner seeks to call in question judgment and call in question order dated 4/7/12/24. Passed by Senior Geologist, Department of Mines and Geology, Bangalore Urban District, whereby the quarrying operations being undertaken by the petitioner in Quarry lease numbers 836, 837 and 838 at Hulle Vennahalli village, Bangalore, Dakshin Taluka. Are ordered to be where is it suspended? Order to be suspended. The said order was preceded by certain facts and events relevant to be noted. It appears that a complaint was filed by one Mr. K.M. Harish. To state that the petitioner has been carrying out illegal stone quarrying operations in the agricultural land number 29/P1, P2, P3 of the Huluvennahalli village, which are the lands adjacent to the quarry lease area of the petitioner. Complaint dated, said complaint dated 28/5/24, figures on record into bracket annexure J, page 80, copy of the said complaint, in which it is stated that the petitioners have illegally included the agricultural lands allotted to Dalit families into their mining activities, and that the petitioners have been carrying out unauthorized stone quarrying. Full stop. The quarrying land and the adjoining lands are utilized for mining purpose, it was stated in the complaint, in such a way that it left no identifiable mark on the original land. It was stated that large pits have been dug unlawfully. It appears that pursuant to the aforesaid complaint, Assistant Director of Land Records, Bangalore South, fixed a date for inspection of the site, along with the Tehsildar, Bangalore South Taluka. The inspection was carried out on 30/8/24. The technical officers of the office of the mining department carried out the inspection of the site and submitted a report dated 15/10/24. In the report, it is stated that as for the site inspection, in the report, it is stated that the inspection was carried out the presence of the complainant and the leaseholder. It was stated that stone quarrying was carrying out in the area for years and the deep pits were found. It is stated further, paragraph, that the Tehsildar has confirmed the report submitted by the revenue inspector. In the report of the revenue inspector, Uluvenahalli village, it was stated that the land of 29 was basically a government land, which was sanctioned by the government in favor of one Siddhaya and Muttaya. It was stated that in the said land, the petitioner, that's the son of late Muni Maraya, and his partners have been carrying out quarrying, lease, quarrying stone, including the agricultural land granted to Dalits, along with the quarry lease granted by the government. It was stated that the quarry lease area was found to be currently mined and had deep trenches. It was there, full stop. In light of the above prima facie effects noticed by the authorities, it was decided to request the technical staff of the Department of Mines and Geology to carry out the drone or satellite survey to ascertain whether the quarrying operations and the lease area overlap and the lease is extended to the area other than the sanctioned area, beyond the sanctioned area.
May I make a submission? It is not reported. It is not, Podi and Durasti has not been conducted. Therefore, it is not possible to, unless Podi Durasti is conducted.
Yes, I will say that.
Bifurcation of land is not done. So they are seeking bifurcation through this.
The order mentioned that the officials of the Revenue Department, the Revenue Department, Mines and Geology Department will be conducting a drone survey of the area and check to check the facts and report about the overlapping of the sanctioned area will be made available. It is pending these THE. It is pending this exercise that the suspension is ordered. Suspension of quarrying operation is ordered in light of the first hand facts noticed. Learned advocate for the petitioner, paragraph, would firstly submitted there is no Podi and Durasti undertaken. Therefore, it is not possible to conclude that the petitioner has extended quarrying operation and that the areas are overlaid. Secondly, decision of this court in the D. Shankar versus State of Karnataka, which was bid petition number 498880 of 29, decided on 7th November 2019, was relied on with reference to the provisions of section 8K of the Karnataka Minor Mineral Concession Rules 1994. The said provision deals with the quarrying operations to be in accordance, deals with the aspect that the quarrying operations shall be in accordance with the quarrying plan, public simplified quarrying plan. Full stop. From paragraph 8 of the said order, it was sought to be highlighted that the court has observed that the suspension of the quarrying operations cannot be acted upon except on the grounds provided in sub-rule 2 of Rule 8K aforementioned. And that no such ground exists. Full stop. The court has considered the aforesaid paragraph to submissions. Rule 8K in terms provide that the quarrying operations will be required to be carried out in accordance with the quarrying plan, public simplified quarrying plan, as approved by the authorities. Full stop. The facts highlighted above and those noted and also noted by the competent authority while passing the order of suspension of the quarrying operations is based on the prima facie conclusion that the quarrying operations are carried out by not adhering to the sanction plan and that they are extended to the agricultural lands. Full stop. The court, however, hastens to add that this is only a tentative conclusion reached by the authorities. Full stop. The authorities are in the process of finally verifying the said aspect, said factual aspect. It is for the very purpose that the drone survey by the technical team of the Revenue Department and the Mining Department is going to be documented.
There is a specialized agency for conducting drone survey. Let them conduct it within a short span of time, Lord, because
Well, not the
quarrying operation has been stopped.
Going to be deputed and the drone survey is conducted. Full stop. It is to be observed, paragraph, that the final conclusion and the final action which may be required will be only after such exercise is completed. The court is of the view that after the drone survey exercise completed, the petitioner should also be given opportunity of hearing and put forward its 10 paragraph. In light of the above facts and aspects emerging, paragraph, the present petition is disposed of by issuing following directions. As contemplated in the impugned order, the drone survey shall be conducted by the authorities within 10 days from today. Within 10 on or before.
Weeks, no.
Within 15 days.
Yes.
Within 15 days from today. Paragraph. The report of the drone survey 1, 2, 3, 4, small 1, 2 shall be made available to the petitioner.
Yes.
Within a week thereafter.
Yes.
Full stop. If the report has any adverse finding against the petitioner 3, so the petitioner shall be given opportunity hearing.
Yeah.
Next, the petitioners have a right to file a reply to the drone survey report and put forward his defense. Full stop. The authorities shall take a final decision by considering all the above materials within two further weeks from the date of such reply, which may be filed by the petitioner.
My Lord,
This court has not gone into the merits of any aspect of the petitioner. Any observations? In this order, will not influence the decision by the authority, which is to be taken on the basis of the material to be available upon the drawn survey and after hearing the petition.
My lord, may I make two submissions? My lord, the drone survey, my lord, the petitioners may be permitted to bear the expenses for the drone survey.
Why should
That
we?
is one. Why should we mean then, okay, it's all right. My lord, the second is, my lord, the second is, my lord, the persons who have complained, my lord, they may also be given an opportunity, my lord, that is one Harish N and Muttu Raju M, who have given complaints.
Filing petition, before filing, taking final decision along with the petitioner, the complainant may also be heard by
Yes,
the authority.
Harish N and Muttu Raju M.
Lord,
Before filing, before.
if they undertake
Authority, in their discretion. If you want to hear, hear. Authority.
No, we'll hear, my lord. Let
Yes,
us
we are-
give it a quiet, Mr. Harishan and Muttu Raju M also.
now, if they are deciding our list between
At their discretion.
No,
the petitioner and the complainant, let them decide.
No, my lord may
What,
take
lord?
paragraph
This
10.
is going to that extent.
My lord,
They want to decide the list between, the dispute
no,
between
the
the petitioner and the complainant. Because they have executed registered sale deed in my favor. The complainant, complaint is motivated in it.
is coming, my lord. My lord may please take page 10, paragraph 10, my lord. My lord, the middle there. He's entered into an agreement. And because the sale deed is not finalized, he's encroached.
Oh, simple. One line order would have been, two line order would have been two paragraph, but we have, now you learned advocate for the petitioner.
No, I'm not, I'm leaving it.
No,
Drawn
fairly
survey.
stated that the petitioner will pay
Bear
the
the-
drawn expense.
Yes.
Clear the drawn expense.
Yes, we'll do it expeditiously, my lord. Let
Lord,
it is paid.
if they undertake the exercise of conducting Podi and Durasti, it will take 6 months. They shall not do it. Because Lord, legally executed lease has been stalled at the instance of motivated persons in this matter.
My lord, what motivated? He enters
No,
into.
no, she is arguing on behalf of the complainant.
I'm not arguing.
No, it is their own record
Let him
says
be fair, my lord.
until we
He
file,
avers.
until we check.
He avers. It is not my information. That's why I said my lord may take paragraph 10. He avers. He produces the document and with a straight face he makes allegations against me. Complainants. They are grantees belonging to the SCST.
If they don't conduct the Fodi and Durasti, and according to you, the Fodi and Durasti is required to be conducted, then it will be good ground for you to urge before them that.
Yes, all those
We
contentions.
don't see any improvement in this order. That's all. So you are bearing the expense. Yes. Which shall be deposited.
No, that will be deposited with the competent authority.
And
Lord, once there is an order, we have to do it.
Yes, next.
Public.
Number 24.
Lord, 24 and 25 are similar to WP 485 of 25.
No, no, it's not. Lord, this matter I have argued, this is, Lord, the decision of the District Task Force Committee that has been challenged on the ground that they have no authority to seek no objection certificate for the second time.
These decisions are not amenable to any appeal or revision.
No, my lord, we just wanted to know, my lord, in a similar matter, WP 485 of 25, my lord had posed that question that since NOC had been obtained.
Lord, in this matter, the challenge is to the proceedings of the District Task Force Committee on the ground that they have no authority to seek no objection certificates Once it has been already obtained, second time they are seeking. In the similar circumstances, your lordship, Lord, by the virtue of the amendment, that provision was deleted. Thereafter, it has been included in the amendment 2023. Therefore, your lordship, Lord, issued notice in the connected matter. Lord, my submission in this matter is, Lord, if I go on challenging this district task force committee's decision, it will take 4 to 5 months. Instead of that, Lord, let there be a direction to the district task force committee, because they are seeking no objection from Forest and Revenue Department. They are the members of the very district task force committee. Let there be a time-bound direction to the district task force committee to resolve this issue, Lord. Let them verify the status of land within 15 days and come to a conclusion so that this matter may be disposed of.
Malad, I'll take notice today, Malad. Today is
All
coming
that
up for
I
the
am
first
seeking
time.
is, Lord, they want to check the status of the.
Then therefore you are indirectly getting the order set aside,
Yes.
this order.
Sorry, Lord.
By seeking such a course of action at the end of the court, you are indirectly getting the impugned order of the task force committee set aside,
No,
which you have, that.
I am accepting that.
You are accepting it.
Accepting that. Let them do it in a time-bound manner.
What is that order then?
The order is they are seeking no objection certificate once again to check the status of the land.
But then it is for you to take the no objection. Who will take?
Authorities will take it. Authorities.
Why you are requiring second time?
Malad, it had been taken a long time back. So to be on the safer side, Malad, as a precautionary measure, we have decided on this resolution. Now, considering that, Malad, the petitioner says there is no change, I will take notice on behalf of the respondents and make.
Lord, there is no provision under the act to seek second time no objection.
Malad,
The role of the district task force committee comes into picture only when there is no objection certificate rendered by the concerned authorities. The role, therefore, I have challenged this order, the district task force committee's order, on the ground that.
Where is that order? Where is the impugned?
Annexure A.
Annexure A, where is the page?
Page 17, Lord, is in Kannada, and the translated version is. The relevant portion of the translation is, Lord, 26. Page number 26.
Malad, the application had been filed.
Now this task, the powers of the task force committee will find.
Place, Lord.
Government. See, you are asking for permissions to be taken once again, NOC to be taken once again
To be on the safer side.
from the Revenue Department and the Forest Department. It pertains to the land, whether it's a forest land or not, or what is the nature of the land. Unless you change it, that question does not arise, irrespective of whether many years have elapsed. And it becomes, on practically speaking, it becomes a very costly affair for the petitioner.
Malad, that's the reason why I sought for some time to interact with the chairman of the task force.
See, asking second time, except
Mal-
he is made to bear certain expenses,
Malad,
it serves no other purpose.
Malad, at least the authorities it should be brought to the notice of the authorities, Malad, that these lapses that are there, how they can, Malad, overcome. It is not because I'm seeking adjournment for the sake of adjournment, but I'll have to inform them, Malad, seek instructions, and I'll make my submission. The connected matter is on 21st.
That you may.
Yes.
But the point is, you'll have to put it across. Taking it second time may be futile.
Malad, if my lord were to recollect, there are new notifications with the forest department says, now, my lord, that this had already been declared as a forest area. So
That
we
you
will
have to
not
come up and say, after all those persons are members of the district task force
My
committee.
lord, that's right. My lord, to see that no such impediment is caused in this case, my lord, I'm seeking for some time.
Now, my submission is very aspect of placing this file before the district task force committee is itself is void because it was unnecessary, unwarranted. The power of the district task force committee comes into picture only when there was no objection certificate received by the concerned department. And they
more so in the light of the amended provisions to Rule 8A and all that, wherein the lease has been increased to 30 years and 50 years. 10 years, I don't know.
My lord, please.
No, in this case, all the formalities are completed. Just to execute lease deed is pending, my lord. At that point of time, this exercise once again.
My lord, the officials cannot be callous, my lord, in their.
The point is that you may exercise your discretion of re-verify, but where will you draw the line? It is 1 year old certificate, 1 day old certificate. In which case we will go for fresh certificate.
My lord, that is to seek instructions from, my lord, the forest department. It is for that.
Some
amendment.
But yes.
So then in this case, you
337, page number 337.
337. Yeah. 337. Rule 9, Rule 8 and 11. Page number is
377.
377.
I want to take instruction.
You can also verify.
My lord, to verify only, my lord, I'll.
No. What you want, what the authority want the petitioner to verify and get the fresh certificate. You can also verify. From your sources, your own personnel officers.
My lord, this is something that I'm sure the lawmakers did not anticipate. My lord, considering that this is coming up, my lord.
Rule?
My lord, the rule 8(6).
8(6). Clause 2 may kindly be seen. In sub-rule 6, the words, the same shall be placed invariably before the district task force mines committee in its monthly meeting by the competent authority. Every month, Lord, they'll hold a meeting. The opinion from the concerned department officer shall be obtained in the meeting and recorded in the proceedings of the meeting and be disposed of accordingly, because they cannot take indefinite time. In the monthly meeting, they have to call the officer and decide it.
Which rule you are reading?
Lord, amendment to Rule 8, Lord, sub-rule 6. Page number 337, 377, I'm sorry.
The same shall be placed invariably.
Immediately before, Lord, invariably before the district task force committee in its monthly meeting by the competent authority. The opinion from the concerned department officer shall be obtained in the meeting and recorded in the proceedings of the meeting and be disposed of accordingly. They cannot, and brackets, it shall be deemed that the deputy commissioner or the tahsildar or the deputy conservator of forest or the assistant commissioner or the deputy director or the senior geologist, as the case may be, has given his no objection, and the district task force committee shall communicate the same to the competent authority for processing such application for conditional grant to that effect shall be substituted. This has been substituted. This provision, in fact, was omitted by the amendment 2020. Again, it was brought into the rule book in the year 2023. Because time stipulation is there in the 2023 amendment to consider all these pending application within a stipulated time. At this juncture, my lord, they want to take one more objection. They are creating, my lord.
Madam, you take instructions, what you propose to do.
My lord, my
They
lord,
will decide it.
yes.
My lord, a short date may be granted.
What date will give? 5th of February.
My lord, the connected matter is on 21st of February. My lord, may
Lord,
grant
it
me
will
time.
go on. Otherwise, my lord, you'll have to get disposed of.
I don't
This-
understand this. Go on, go on, go on. What goes on, I don't know. Even they should get some time to reply, my lord.
My submission is, if 1 month time is granted
Yes.
for them to reply,
They are granting one.
1 month or 15 days, Lord, my submission is, this issue may be resolved. If they really want one more
Verification.
objection or verification, whatever it is, they can do it within 15 days, because in the monthly meeting, they have to decide it.
My lord, he's not.
Instead
my
of
lord,
keeping it
friend
pending
is
for
not
a long time.
understanding what I'm submitting. It's coming up for the first time today, my lord. I'll take notice, intimate the DC, and then I'll get back to my lords. If my lord were to grant me a short adjournment, again I'll have to move for an adjournment.
6th of February.
My lord, connected matters on 21st.
All right, 20. But on
Obliged.
21st to be listed at 2:30.
Yes.
You take instructions.
Yes, yes.
Learned additional government advocate. Ms. Neela Farakpur to take instructions as to the course of action the authorities propose to take pursuant to the impugned decision of the task force coming. Which is the other matter?
My lord, my lord, WP 485 of 25.
WP 485 of 25 shall be listed along with the present. Yes. No.
25.
Gulal.
Same. 25.
No, same, not same.
Both are same? No.
No.
Lordships kindly, my lord. Serial number 32, my lord, stay. 32, serial number 32 in the list.
32.
In fact, I have served all my colleague has served all the papers of the week. The afternoon is difficult day.
We want time.
Yes.
Take date, whatever
32,
date.
yes. February 1st week or anything.
February 1st.
Somewhere.
Then 12th February.
12th. Serial number 1 in
13th February.
serial.
Then it will go later. 24th February.
Serial number 1 in second list. Tomorrow, election for the post of Adhyaksha of Grama Panchayat is scheduled.
Second list is
Yes, sir. Second list.
We'll take up 2:30.
Please. Tomorrow it is.
You.
Please.
Sir, court officer? Court officer, ಇದೀರಾ ಏನಾರು? ಎಲ್ಲಿ ಬರ್ತಿದ್ದು? ಬೆಂಗಳೂರು ಬೆಂಚ್ ಕೊಟ್ಟೋಗಿದೆ.
ಹಲೋ ಹೇಳಿ ಸರ್, ಯಾರು? ಮ್ಯೂಟ್ ಆದ್ರು. This is for pronouncement of judgment. Seal number 1, writ appeal 632 of 20. Seal number 1, writ appeal 632 of 2024.
So appeal is dismissed.
Much obliged.
My lord, on submission. Kindly the interim order will be extended for 2 weeks, my lord. Interim order, sir.
Order is operating.
Sir, my lord, for the stay, my lord. Interim order of stay.
At this stage, learned advocate, Mr. So and so, request for continuance of the interim order.
Sir, for 2 weeks. For 2 weeks.
In view of what is held by the court, herein above, comma. What do you say?
My lord, the interim order extension does not arise when it's to.
At this stage, conspiracy learned advocate, Mr. So and so, request the court to continue the interim order for some time. Full stop. The request was objected to by learned additional advocate, Ms.
Shweta Krishna.
Krishnappa. Paragraph. In view of, in the facts, in view of what is held by the court herein above, the request cannot be acceded to. It is rejected.
Much obliged, my lord.
Seal number 2, writ petition 797 of 2024.
So we have disposed of the public interest petition. Given certain directions to the Department of Health and Family Welfare to constitute 3-member committee headed by the secretary to oversee the mechanism for providing the medical facility in the urban area, semi-urban area, and rural area. Similar committee shall be constituted at the district level. The committee shall oversee the filling of the post, extension of medical facilities, increase in the number of primary health centers, and all such matters. And the committee shall periodically, that is every 6 months, take a review of the situation and the healthcare services. So lastly, we have said that in view of the vacancy position of medical officers, technical assistants, and other staffs, and the fact that the process of recruitment is pending since 2022, you will file an affidavit as to the status of the process of recruitment. And file the affidavit indicating the timeline within which we will complete the process, which is already initiated in 22. And we give 10 weeks time to file affidavit. Even while we dispose of the petition, the affidavit will be filed on the record of the petition. If you.
Lord, could I have a copy of the order so that immediately I can communicate to the secretary and
Get this a copy of the order today on 5th, on not 5th, day after tomorrow.
Very
morning.
Even uploaded on the website. If you upload.
And the matter shall be listed after 10 weeks for the purpose of compliance of your filing of affidavit.
Obligement.
Seal number 3, writ appeal 971 of 2024, connected with contempt 608 of 2024.
Writ appeal 971 of 24 and contempt 608 of 2024. Writ appeals are dismissed. In view of dismissal of appeal, the contempt petition would not survive for consideration, same is dismissed.
Seal number 4.
My lord.
Contempt
Should survive, my lord. For non-compliance of.
We have provided extension of time for compliance of the learned single judge.
Case number 4, so commercial appeal 427 of 2024, and other connected 11 matters.
Commercial appeal 427 of 24 and other connected matters. Appeals are allowed in part. The judgment and order in company application, commercial application number 106 and so on so, passed by additional cities civil and session judge Bangalore is hereby set aside and the matter is remitted for fresh consideration. The commercial court shall examine the aspect of payment of rupees 3 crore 50 lakhs. And if it is found to be part of the claim amount before the arbitral tribunal, appropriate set off or adjustment shall be made to that extent. Please, findings recorded by this court, however, shall not influence the court below while undertaking the exercise as directed above. The other findings as recorded by the arbitral tribunal and in the application under section 34 of the Act are not interfered with and they are maintained. Please.
Much. Case number 5, writ appeal 352 of 2023.
Writ appeal is dismissed.
kindly, seal number 95, Your Lordship. It pertain to collection of tolls, where incomplete tolls also, they are collecting tolls. IA has been filed for direction. My request is that the IA may be listed on any date, convenient date, so that the Lordship can hear the IA for direction. I already informed Mr. Madhukar Deshpande, who appears for the Union of India also, Lordship. Morning I informed. IA may be listed, that's my request. Because what is happening today also, it has come in paper. The Bangalore-Mysore Expressway, crimes are taking place, and there are no facilities even for women and other things, for restroom or whatever it is there, because it stretch is not any safety measures are not taken up basically in that. So that also memo I have filed earlier. So, and there is a 2013 rules framed by the Union of India. That rules still not followed, incomplete highways, they collect tolls. All these issues of IA may be taken. My request is IA, if Your Lordship can come to the conclusion, the IA can be considered, and based on that, the other thing can be.
Entire petition will consider.
But IA, because IA particularly 2013 rules, Your Lordship, and which is raised because recently in Ankola, NS 66.
Who appeared? Madam, you are appearing?
The government.
So when shall we take? 19 February,
Yes,
6 February,
yes,
6 February.
Please.
10 to 6 February, come as requested.
41st matter. 41st matter.
41st.
41st, list number 1.
31st.
No, there are some office objection is there.
Which serial
I
number?
want to come.
41. 41st. New way of telling. 51st. Or 51. 41st.
40.
Yes. What do you want?
I want to, the respondent has to complete an office objection. So he plays 2 weeks time.
Respondent has to complete work.
Yes, because the office raised objection regarding two documents.
No, it is listed for hearing. Listed for hearing, Mr. Not for office objection. It is
Sir,
listed.
it is not my case, it is my colleague's case. He is not in the station. He requested me to take a date.
You want time, isn't it? March. 6th March.
List number 2, seal number 1, Mr. Ramesh KR.
I appear for the appellant in this matter, my lord.
What is it?
Lord, the appellant herein had filed a writ petition before the learned single judge of this honorable court challenging the no confidence motion moved against the appellant, my lord, as per annexure A. But the only ground urged by the petitioner in the appellant in the present appeal is that, my lord, before the expiry of the period of 15 months from the date of assuming the office as Adhyaksha of Gram Panchayat, the Gram Panchayat, my lord, no confidence motion is moved that has been accepted. Lordship may kindly page section 49 of the Karnataka Panchayat Raj and Gram Swaraj and Panchayat Raj Act 1993. But the appellant herein was elected as member of Gram Panchayat on 30/12/2020. But she has been elected as Adhyaksha of Gram Panchayat on 18/7/2023. Then, my lord, she has assumed the office on 5/8/2023. No confidence motion is moved, my lord, on 25/10/2024 before she completing 15 months in the office as Adhyaksha of Gram Panchayat. That's the only ground, my lord. Section 49, proviso to section 49 of the Act.
provided also that where a resolution expressing want of confidence in any Adhyaksha or Upadhyaksha has been considered a negative. The appellant's tenure come to an end, my lord, on 4/11/2024. No confidence motion is moved on 25/10/2024.
By no confidence motion. Even she's entitled to participate in the elections. There will be issue not to incur in.
What was the date of your election?
Lord, election is on, my lord, 18/7/2023, but I assumed the office, my lord.
7/3/23.
Please, my lord, I assumed the office on 5/8/2023 till 4/8/2023. Previous Adhyaksha continued to be in
No,
the.
in your case, it is that.
18/7.
Election was conducted on 13/7/23. Period of 15 months would commence from the that date,
My lord,
which
that
would expire on 12/10/24.
it
No
is.
confidence motion ought to have been initiated only after 12/10/24.
That is not.
Done on 23.
But that is
This
wrong.
was.
In the impugned order that is wrongly typed as 13, my lord, it is 18. 18/7/2023 is the date of election. Assuming the office on 5/8/2023.
It is after 15 months.
If it is taken from the date of I assuming the office, my lord, the intention of the act is to provide at least minimum 15 months in the office as Adhyaksha. If it is taken on from the date of assuming the office, my lord, 15 months has not been elapsed, my lord. That's the only ground.
That's the only ground that for dismissed. Sorry, very clear, Mr. Even the section says from the date of election. We'll pass the order.
Please.
List one. So 230 matters. Still number 96. So Prasad K.R. Rao. Still number 96.
What is it?
Similar matters have been disposed of. This is, we have also filed the affidavit.
Similar matter, how can? What is there? Writ petition. The writ petition came to be disposed of by a single judge by order dated 2nd November 23, providing that the issue was covered by decision of the coordinate bench in TILT room 2 versus State of Karnataka, which was writ petition number 20532 of 2023, disposed of on 20th 9/23, in which read again, what is it? So and so, so and so, decided in so and so and so. And that the directions scheduled in the said decision would apply in the case. Those directions are reproduced found in paragraph 6 of the said decision. They are as and take from this. In the present case also, identical directions are brought under contempt jurisdiction paragraph in in Messrs Meta Hospitality Private Limited, Supra Meta Hospitality Private Limited versus State of Karnataka, which was contempt petition number 97/24, decided on 18th March 24. Identical directions were subject matter of contempt jurisdiction. The court observed as in paragraph 2, court 2 and 3. Full stop. The same observations and directions will apply in the present case. The present contempt petition is accordingly disposed in the same terms. So it is only one or one matter?
Please.
This is number 97. P. N. Nanjareddy.
Lords, this matter, AAG is appearing, Lords, should I grant it sometime?
But they file a compliance affidavit stating that my case will be considered for promotion
when the existing pending charge sheet is decided. 1 month before that date, my lords, the order has been passed, which I have placed along with the rejoinder, withdrawing the charge sheet itself. 28th June is their 28th June is their compliance affidavit, stating that the charge memo is pending and therefore they would consider my case for promotion after the charge sheet is disposed of. 1 month earlier to that, my lords, on 28th May 2024 itself, they have withdrawn the charge sheet. Therefore, it is a false affidavit they filed. Yes.
Lords, AG is appearing in this matter, my lords. I request some time to. Next week it may be taken up. To produce certain documents, my lords.
My lords, may kindly see, my lords, the so-called compliance affidavit they filed, which they say, my lords, at the para 6. I further say, in view of the above mentioned, the respondent authorities have issued the endorsement rejecting the claim of the complainant for retrospective promotion, and the endorsement states that his promotion will be considered in the next DPC, subject to the outcome of the departmental inquiry. This affidavit is dated 27th of June. Their endorsement is 25th of June, where in the endorsement, that is annexure R1, last paragraph, last sentence, after completion of these departmental inquiries, your promotion will be considered as per rules. 1 month before this affidavit, my lord, the sole pending inquiry, they are accepting that there is legal infirmities in the charge itself. They have withdrawn the charge memo. That order is dated 28/5, which I have placed along with the rejoinder. First, in the writ petition, they made a false
May I
submission
have
that
it on
there was charge sheet
29th?
pending.
Lords may have it on 29th, my lords.
Number 98, the GM Nataraj for complainant. For complainant.
The order is not yet complied with, but what they have done is, the direction is to allow the public to bury the dead bodies in the land reserved in accordance with the order dated 27/8/2010. But in the affidavit, what the estate commissioner said is, just he has erected a board and saying that order is already complied with. But in the order dated 27/8/2010, it is clearly stated that that land has to be handed over to the municipality for maintenance, means that land has to be demarcated. And that land should be made available to the public. Is the order passed by the, in this order? That is the order.
Page 42 is the order, my lords. 42 and 43, paragraph 6. The direction is the Assistant Commissioner Sagar to permit the members of the petitioner to use the land in survey number 14 of Yelavarsi village, Sagara Taluk, for burial purposes along with other members of the public. My lords may kindly take the compliance affidavit, my lords. My lords, paragraph 3 may be read.
Please. In the para 6 of the order also, in view of the aforesaid submissions, as well as taking into account of the order dated 27/8/2010.
Yes.
That is the order passed by the Deputy Commissioner, wherein Deputy Commissioner has reserved that land for burial purpose. In that order, that translation copy is at page 14. It is clearly stated that Pursuant to the request made by the City Municipal Council Sagara, the land bearing survey number 14 measures 10 acres situated at Yalavarsi village, Sagara Taluk has been reserved for public burial ground under section 71 of Karnataka Land Revenue Act 1964. The Tahsildar Sagara Taluk is directed to hand over the land to the Commissioner, City Municipal Council Sagara. The maintenance of the land which is reserved for the burial ground to be carried by the City Municipal Council Sagara, and the following conditions are imposed. Means that land has to be handed over to City Municipal Council for maintenance. But simply they have said that by putting a board, you are allowed to bury the dead bodies is not highly impossible, because that maintenance is not done, that land is not demarcated. If you take a dead body to bury there, the neighbors will oppose that, because there is no demarcation is done since 2010. What I am seeking is just demarcation to be done.
Done,
Then we will not seek anything more than that.
Lords, may
Otherwise,
kindly see
that
paragraph
order,
3.
purpose of that order will not serve.
Para 3, my lords, we have very clearly said the land has been transferred to the city.
Only demarcation we are seeking.
Lords, and survey sketch has been made. And now the land actually belongs to the city municipal council. It is not in the revenue department. There cannot be a contempt against the revenue department because the land is with the city municipal council, my lords. Even RTCs has been entered, and we have shown in RTCs that 10 acres of land is reserved for public burial purpose. Sketch has been made. My lords, it is in total compliance. We have filed the affidavit, my lords.
Already land was granted in 2010. Already 14 years are over, but that land is not available to the public. In the affidavit also, what are the efforts made by them is not stated. Just they said they have erected a board and allowed the public. Looking into the board, we cannot take the bodies to bury there.
The lords
That
may
is the
kindly take
problem.
the RTCs.
Allah,
In the RTCs very clearly it
Allah,
says that it
Allah,
is
that is
reserved
all
for public
over.
burial.
It is over.
It is page 8, my lords. I do not know what is in what manner compliance has to be done. 8, my lords, it says that your lordship might see column number 11, where it clearly says it is for public burial ground, and MR also is mentioned here, where it has been transferred. And we have also a board has been erected, my lords, which is also photograph has been produced. And we have made a survey sketch also of the land.
Allah, here we are not seeking grant afresh. Already grant is made in the year 2010, and that land is
Only
land is there, but only demarcation.
Direction
That is
to the
enough.
assistant
That will
commissioner to
serve the purpose.
the members of the petitioner to use the land, my lords. They can use the land, my lords.
Already existing burial ground is filled up. During the epidemic also, they have taken the bodies to their villages to bury the dead bodies. Assistant Commissioner being a responsible officer, he has to take into note that that land is not made available. Just let them demarcate the land.
Sketch is done, my lords.
There are people are in great hardship there because there is no land.
It is transferred to the
City Municipal Council.
ಇಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿಲ್ಲ ಅದು that earlier one of the communities have filed a writ petition. Only 2 acre of land out of 10 acre of land is made available to only one particular family, particular community. For that we are not disputing. This petitioner is seeking that land to be made available for their community. That is with regard to only 2 acres of land out of 8 acres of land is still lying vacant. That demarcation was done in pursuance of the order in public interest litigation of WP number 46420 of 2013. For this community only land is given.
along with other public areas.
But we are concerned it is not permitted, not yet permitted to bury the, and not made available, no demarcation.
As per the order under contempt, they disposed of by directing the assistant commissioner Sagara Taluka, Shivomagoga district, permit the petitioners to permit the members of the petitioner to use land survey number 4. At Kalavasari village, Sagara Taluka, for burial purpose along with other members. The non-compliance survey of the above direction is alleged by filing the present contempt petition. Petition was responded by filing compliance affidavit. In the compliance affidavit, the assistant commissioner, one Mr. Yatish R, son of Sri Radha Krishna, stated thus: from expecting relevant part. Where is that? Yeah, he stated thus, extracting from paragraph 3. Bracketed portion. Comma, thus after quoting paragraph, bracket, thus the land in question is earmarked for burial ground. It stands transfer formally to the Commissioner of Sagara City Municipal Council for the designated purpose. There is no question of community of petitioner or any other community not permitting to use the land as burial ground, since it is reserved for burial ground. The court does not see any justification to allege contempt on any count, more particularly when no instance is pointed out that either any of the community is prevented from using the land as burial ground. The petition is dismissed.
This is number 99, Mr. A.J. Srinivasan.
This is against the order of the, there are retired professors who were entitled to gratuity under the Amendment Act, which made provision for even professors in educational institutes get gratuity. And since the controlling authority, which was the authority, passed an order which was not complied with, we approached the Honorable High Court, and the single judge passed an order stating that the institution, educational institution, should pay us the gratuity which was ordered by the controlling authority, failing which the district commissioner is to initiate recovery proceedings under Section 8 and pay it to us. That is the order which is available at page 13, my lord. Now, what has happened is, it appears they have filed a compliance affidavit. Of course, the DC, who is the accused herein, he has not filed the affidavit. It is filed by the Tahsildar, saying that they have recovered the amount and they have kept it with them. Section 8 is what the directions given is, District Commissioner is at liberty to initiate recovery proceedings in accordance with law. That is Section 8 of the Payment of Gratuity Act says it should be recovered and paid to me, the professors. A decade has passed. Now they are all in their 70s. Man. They have not got their gratuity also. Now, the first and the second and third heads of the institutions, they were required to pay me, first of all. That is the contempt which they have done, my lord. And in respect of the first complainant,
Appears for number 2 and 3.
2 and 3.
Notice may go to.
2 and 3, nobody appears.
Now, they have filed a writ appeal 6 months before. They don't comply with any of the objections, my lord. It is also listed at serial number 87 today, my lord.
Let us wait.
87 it is quoted. And they don't go on with the appeal also, my lord. I am the caveator there. They don't serve a copy also, my lord. And in the meantime, they don't comply with this, any of the provisions. And these professors are still at 70s. They are still waiting for their gratuity.
Let's let the respondents be made a party here. Let notice go to the respondents, my lord.
They are made a party, my lord. And they have been served also. They don't appear. They are shown in the court title in the. They are not, they should be held in contempt, my lord, because they don't bother to even appear before this court.
What they have done, my lords, they have deposited the
Appeal is
amount.
filed by whom?
The institution.
The institution has filed it, and for last 8 months, 7 months, they don't even comply with the objection of even serving a copy.
Where it is listed?
Today it is listed at serial number 87, my lord. Still, it is for compliance of office objections, my lord.
87.
Yeah. And my lord, your lordship is aware under the Payment of Gratuity Act, if an appeal is to be preferred, there's an appellate authority. They cannot approach the High Court. The appellate authority, my lord, and within 120 days, if they don't file an appeal, the order becomes final. The learned single judge has observed that the order has become final. There is no scope for appeal also, my lord. The appeal should be filed within a statutory period of 120 days, which is otherwise the order becomes final. There is no more. Supreme Court has said it cannot be, no appeal lies thereafter. They approach the High Court directly, my lord.
Who are the private parties?
My lord, they are institutions, my lord. Your lordship may see Siddha Ganga Institute of Sri Siddha Ganga Institute of Technology, my lord. 2 and 3, my lord.
Notice written on 4th March.
They are served, my lord.
But private parties are served?
They are served, my lord. It's shown in the court title, my lord, as served.
All are served?
They are not appearing before this court, my lord.
99.
The BC also should disperse the amount to us, my lord. And Section 8 says, unless there is a stay, they have no right to withhold the amount, my lord.
That's we do not have the amount. The institution, my lords, they have deposited with the labor court, my lords.
No,
because the writ appeal was pending, they have deposited before the labor court.
The compliance affidavit, that's not the what you are
Labor
saying.
officer and controlling authority. And
That is the controlling authority is the labor department, my lord. They are the ones who are required to recover that the Tahsildar has recovered that amount. And he has filed an affidavit, not the DC is required to file, my lord, the affidavit. He has not filed the affidavit either. And merely, Section 8 says it has to be recovered and paid to the workman. That part is not complied with as required under law, which is the direction given to them by the single judge. To that extent, they have not complied with it, my lord.
Just find out. We'll find out. 6th of February.
Number 100. Ajay Jain. Good, my lord.
Government advocate had said that they would withdraw the original proceeding itself, my lord. Your lordship said been pleased to grant an interim order on the ground that the demand is not preceded by any assessment. Please see, my lord, your lordship's order, my lord, on 28/10.
I'm filing a memo, my lord, seeking permission to withdraw the demand notice with liberty to issue a fresh show cause notice and start the adjudication process, my lord. That liberty may be reserved, my lord.
The writ petition, my lord, may have to be
Even the
withdrawn
writ petition may not survive, my lord.
procedurally, my lord. This is an appeal against an interim order. So your lordship, my lord, may have to withdraw the writ petition and dispose of the writ petition.
Paragraph 2 may kindly be seen.
Now what has happened?
My lord, what has happened, my lord, is they issued me a demand without any preceding assessment. I challenged it in the writ petition. The learned single judge, my lord, issued notice and directed us to pay 25% of the amount. We challenged that interim order before your lordships. Honorable Court, my lord, has been pleased to pass an interim order staying the 25% deposit, noticing that this demand was not preceded by an assessment. Now, my lord, my learned friend says that the impugned notice before the learned single judge, which is Annexure A, they would like to withdraw. My lord, if they want to withdraw it, then my lord, nothing will survive in the writ petition. So
Writ
your
petition,
lordships
nothing serves in the writ
have to
petition.
withdraw the writ petition and pass an order, final order in the writ petition. Only other submission I have, my lord, is that the basis on which they made this demand, directly on the point, there is a judgment of the learned single judge which says that this demand, such a demand cannot be made. Because what they're doing, my lord, is they're assessing the output of beer on the basis of malt and other adjuncts. The learned single judge in another case relating to our own manufacturer, they said it can't be done. So all that I'm saying, my lord, is if they withdraw this, I cannot object to it. I'm only saying if they want to institute any proceeding, it should be according to law. And that law is
You have
now
stated
laid
so, my
down
lord.
by
We
the
will issue
learned
a show
single
cause
judge.
notice, hear them and pass an appropriate order, my lord. That is what request has been made in the memo, my lord. The demand notice itself is being withdrawn now.
The prayer in the writ petition is at page 87.
This was against interim order.
This was
Against
against
an interim
interim
order.
order. Learned single judge, my lord, directed us to deposit 25%. Your lordships, my lord, after hearing, noticed that this demand has not preceded by any order and it is based on some audit observation. No order was passed at all. So your lordships were pleased, my lord, to stay that portion of the order. Now my learned friend says he is withdrawing the original demand itself. The demand, my lord, is Annexure A at page 93. The prayer in the writ petition was only to question this Annexure A, page 93. The learned single judge's interim order, my lord, is at page 29. At 30. Last para, my lord. Prima facie case is made out. Respondent is directed not to take coercive steps pursuant to demand Annexure A, subject to petitioner depositing 25% of the demanded amount. And your lordship, my lord, interim order is 28-10-24, last sentence of that order. Para 7. The memo now says Annexure A, they want to withdraw.
Nothing survived.
Nothing
That's what-
survives, my lord. We are withdrawing the demand notice, my lord. All that we are seeking is liberty to issue a fresh show cause notice, hear them and pass an order of adjudication. That we shall do in accordance with law. This demand notice, what they have impugned in the writ petition, my lord, we are withdrawing it, my lord.
Learned additional government advocate, case service, I'll say memo. Submit that. Judgment and order. In writ petition number 26813 of 24. Was filed. Dismissed.
My lord, in the memo, they say proceed with the show cause notice. There is no show cause notice at all, so they'll have to issue a notice.
We shall be issuing the fresh show cause notice,
Yes.
my lord. I am
By
seeking liberty
issuing-
to issue a show cause notice.
In accordance with law, you may act.
Yes, my lord, we will hear them and we are seeking liberty to issue show cause notice.
Writ petition could be disposed of, not by withdrawal to your lordships.
This contempt was arise from order dated 1st October 24, passed in.
No contempt.
No contempt,
No
lord. This is
contempt.
a
No contempt.
appeal against interim order, my lord.
Serial
Then
number
it's
100.
single judge's interim order. So writ petition may be, my lord, withdrawn and disposed of.
Yes, next.
Get-
One zero one. Mr. Mohan Kumar D.
For the respondent number 5.
Okay. Serial number.
My lord, there is a delay of 37 years to approach the Assistant Commissioner. During the last date of hearing, my lord, a submission was made by the advocate on record, submitting that where he has sent a communication to the appellant, stating that he would retire from the case. And on that submission, my lord, this honorable court accepted the memo of retirement and then ordered for issuance of the court notice, my lord. Now, according to the submission made by the Land Council, my lord, he has been communicated. Now, it is another, according to me, my lord, this is another way of taking an adjournment after this honorable court had granted sufficient opportunities. Lord, now the junior counsels of the advocate who retired is present before them.
No, my lord. So we have only filed a retirement memo. Just my name may be deleted. My name may be deleted. My senior name, Mohan Kumar.
It was Mohan Kumar.
Mohan Kumar, my senior, my lords.
Yeah.
Name may be deleted, my lords. We have filed, in the last date of hearing, we have filed a retirement memo.
Notice is issued to the appellant. What happened?
So, wait.
So? Not so. Awaiting. Let it await. 5th of, to be listed on 6th of February. Awaiting the service of notice. To be listed at 2/3.
Number 102, Mr. Manjunath K.
Your Honor, last occasion I could not attend my mother was expired. One more objection is there. I will attend next time. We will attend next.
PTCL not applicable, it is a grant certificate, document of title.
Only regarding jurisdiction, Your Honor, we'll attend next time.
Or learned advocate, Mr. So-and-so, so-and-so. Okay, appellant, learned additional government advocate. For the respondent state and its authorities. The appeal is directed against judgment and order dated 4 July 23 of law in a simple judge whereby writ petition came to be allowed. Paragraph. The original petitioners was the heir test son of the purchaser of land.
Kindly give me one more time. Because of my mother expired, I could not properly attend. Only regarding the jurisdiction of Your Honor. Jurisdiction of the writ petition, office objection regarding the jurisdiction of the, kindly give permission.
Pardon?
Objection regarding the jurisdiction, Your Honor.
The challenge before learned single judge was
I will attend next time.
against the orders passed by the assistant commissioner, confirmed by the deputy commissioner, whereby the restoration of land was ordered in favor of the original grantee. Under the provisions of scheduled tribe and scheduled caste. Individual transfer Act Karnataka, Act 1978. The facts to be noted paragraph. The relevant facts were that the land bearing survey number 14 at measuring 1 acre, situated at Chinnapura village, Vakkaleri, Hobli, Kolar Taluk, came to be granted in favor of one Narayanappa, son of Bhairappa, B-Y-R-P. Happened to be the husband of respondent 4. The grant was on 2/2/1980. The original grantee sold of the land in favor of the father of the petitioner by a registered sale deed dated 17/8/1995. After the death of the original grantee, the present respondent 4 to 8 who were the heirs filed an application under the 1970 Act seeking restoration of the land in their favor on the ground that there was a breach of the provisions of the Act. Such application was filed in the year 2014. It was after long delay of 18 years.
Question of delay is also not complete. Amendment is adjudication is pending, Your Honor.
In addition that the ground of delay was a valid ground on which the authorities ought not to have restored the land in favor of the grantee, and the application could not have been considered as per the law laid down by the coordinate bench in XYZ versus ABC, which was writ up in 210
210 of 2023.
of 2023. Full stop. The reasons, the discussion and reasons supplied in the said decision would apply to become part of this order in this case. Additionally, paragraph, additionally, the Honorable Single Judge has noted that the land was granted under a grant certificate under form number 1. It was thus a title of document in favor of grantee. The PTCL Act was not applicable. The question of restoration of land.
Your Honor, it is not a grant, it is a granted land, Your Honor. It is not a public auction. By assumption, the lower authority has come to the conclusion of the
Therefore, the petition
assumption,
for
Your Honor.
restoration
There is
of
no
liable
pleading in
to-
any
liable to
lower court,
reject.
Your Honor.
Full stop in the circumstances.
I will furnish the details in the next.
Now, do you belong to scheduled caste, scheduled tribe community? Narayanappa, did he belong to scheduled caste, scheduled tribe
Yes,
community?
Your Honor.
Huh?
Yes, Your Honor.
But there is not the contention before the assistant commissioner.
Because
Was
of
the land,
granted to the Naranappa is SC, Your Honor.
he is a scheduled caste, is
Yes,
it?
Your Honor.
Okay, then second,
It is a granted land, Your Honor.
no. Was it for an upset price or a free grant?
Free grant, Your Honor. But it is assumption of the lower authority, Your Honor. I will substantiate the next year date, Your Honor.
Was it free grant or for an upset
But it-
price?
Even upset
What was
price,
issued was form number 1, my lord. It
Huh.
was an auction purchase. Lordship may kindly see paragraph 5 of at page 15 of the impugned judgment, my lord.
Huh.
The finding is that the grant certificate was placed before the learned single judge. After looking at the certificate, the finding given is that the property has been purchased in public auction.
Public auction.
Public auction,
So
form
it's not
number
a granted land.
Please, my lord, form number 1 at page number 58 has been granted, which is a title document. Therefore, PTCL
And,
Act doesn't apply.
Reading of this page number 18 or 27,
Please.
the proceedings before the deputy commissioner.
Please,
One of the main pleadings is Narayanappa was not a scheduled caste.
please, my lord. Even
Don't-
otherwise, my lord, the form number 1 has been issued,
Form
which is a title document. Property has been purchased in public auction.
Hmm.
Therefore, PTCL Act doesn't
PTCL
apply
Act
here.
does
That is
not
the
apply.
finding at paragraph 5.
Yes, in the light of full bench
Both
judgment.
counts, my lord, the petition is not maintained.
Your Honor, if it is a public auction, the sales certificate has been issued under section 124(4) of the Land Revenue Act, Your Honor. It is not a public auction, Your Honor.
And there is a delay of 18 years.
18 years, my lord. That is also observed at
Thus, the provisions
paragraph
of
2,
the
my
Act
lord.
were not applicable. Full stop. Learned single judge was justified in relying on.
If it is a public auction, Your Honor, under section
That the-
form number 41 rule 124(4) of the Land Revenue Act, certificate has to be issued by the concerned authority. It is not the, it is under SC/ST Act nalli given the certificate, Your Honor.
In this regard.
You see, if it is a public auction, the form number 41 under rule 124.
In this regard, the learned single judge was entirely justified in relying on the decision of the apex court in BK Muniraju versus State of Karnataka, 2008 for SCC 451. The land was found to have been
It
purchased
is only
in public auction
assumption, Your
on
Honor.
both the counts, therefore, learned single judge was justified in arriving at a conclusion to allow the writ petition to set aside the orders of the assistant commissioner and deputy commissioner. No error could be booked, paragraph. In the judgment and order on a single judge, the appeal is meritless, it is dismissed.
Number 103, Sri AV.
Hardships have issued notice in the another writ appeal, which is arising out of this very same impugned order. It is listed on 11/2/2025, next month. Appellants are the same, only private respondents are different, my lords. We have challenged the impugned order by filing separate writ appeals. The connected writ appeal, your lordship shall issue notice, my lord. That is writ appeal 773 of 2024. I mean,
Arising out of same judgment.
sorry, Mali?
Arising out of same judgment.
Same judge.
So stated that, so in this appeal, the notice is not issued.
In this.
So stated that writ appeal number so and so is
Notice and application for condonation as well as.
subjected to notice by this court arise from the very judgment and order impugned in this appeal. Therefore, there shall be notice in the present appeal also, returnable on 11/2/25.
Much obliged.
Office objection shall be complied with before the next.
Please, please.
Bill number 104, Mr. V. Anand. Bill number 104. Mr. V. Anand.
What is it about? Same, you can. None is present. Send over to 4th of February to be listed at 2:30.
List one, number 25. So mind right.
Appear for the petitioner.
Yes, what is it?
Not that. The petitioner has been granted with Form C license for running crusher. This crusher unit was established in the year 1993. At the time of establishment of this crusher unit, Lord, there was no regulations in place. General license used to be issued for running a crusher unit. Lord, the regulation, the Karnataka regulation of Stone Crushers Act came into force from the year 2011. Thereafter, Lord, as per the regulations, a safer zone was declared in the year 2013. It was initially, Lord, the crusher was established in survey number 9/1 and survey number 9/3. Total extent was 7 acres 36 gunta.
Will reply.
Lord, here, annexure A is the order of Lord Caesar passed by the geologist. Geologist has no role to play, because here the applicable act is the regulation of Stone Crushers Act, and it is only the licensing authority, they have powers to regulate the stone crusher units. So, Lord, the geologist who has no authority has confiscated the stone crusher unit on the ground that it has been established in the adjacent survey number. It is so happened, Lord, this petitioner has quarry as well as crusher. Crusher was installed in survey number 9 and quarry was granted in survey number 10. There was no podi and duras was conducted in respect of these two survey numbers. This crusher has been running right from the year 1993. 2 safer zone notifications are there. Joint inspections have been conducted. And after compliance of all statutory formalities, Form C was issued. Lord, in the year 2020, Lord, this survey number 9/3 was bifurcated to survey number 9/6 and 9/7.
But today we can't grant any relief to it.
Lord, so far as annexure A is concerned, Lord, confiscation is done by the geologist without authority of law. There was no notice, prior notice issued, and annexure B is.
There is the confiscation, but.
Last may kindly see annexure A.
Inventory.
Annexure A.
Then it says that.
And the relevant portion is Lord, translation.
Latitude and longitude.
28, page number 28, please, Lord.
Then
Relevant
they said
portion.
the crusher unit is established outside the safe zone. Has been taken into government custody.
Yes,
My lord, may I make one submission? My lord, please take page 16, ground 22, 23, 25. Even 20 may be seen, my lord. Ground 20, 22, 23, and 25. Admits,
Lord,
admission. Established
Ye-
outside the safe.
You talk about attachment.
yes,
It is attached and given to you only. It's only a paper attachment. Because the machineries can't be moved. They have to be placed where they are.
that is true.
And it is given to your own safe custody.
Now the crusher.
Only thing is you have been asked not to operate them because you have installed it beyond the area that has been granted to you in your license.
That is the misconception. The thing is, that is why I have submitted.
That's what Annexure A says. We don't know.
Yes, yes.
There is no attachment because it is stated since the crusher unit has been permanently installed.
This is
on
so
the ground.
happened, Lord. Last may kindly appreciate. This is so happened. This pressure unit has been running right from 93 in the same place. 2 joint inspections were conducted. Authorities inspected. Geo coordinates were fixed. Only in the year 2020, this bifurcation of survey number 9 and 10. 10 also, I am running a quarry. In the similar circumstances, Lord, if there is a displacement of area, the crusher unit will be allowed to shift to the safer zone. There was a provision in the transitions during transition stage, because Lord, then there was no regulation in the year 1993. Only in the year 2011, this act came into force. During transition stage, Lord, 6 months time was granted to shift the same to the safer zone area. Here also, I have no problem to, since it is demarked now, I have no problem to shift it to the safer zone. Lord, the survey number 10, while inspecting the officials of the Department of Mines and Geology, while inspecting the quarry area for extension of lease, at that time, based on Dishank app, they noticed that this might have installed in survey number portion of survey number 10. That is how it has happened. It is there on record. I'm not submitting off the record. Now, all that I am requesting is for the resurvey and permit me to shift if it is on that survey number 10. It can be safely shifted to my own area in survey number 9/6 and 9/7. And so far as procedural aspect is concerned, the senior geologist has no authority. It is only the licensing authority has the authority to either take any action against crusher units. That is the judgment of this Honorable Court. Even the chairman of the district licensing authority has no power to pass any order against the crusher unit. I'm placing that also on record. And one more judgment to the effect that, Lord, if I am permitted to shift the crusher unit to the safer zone, I will do it in a time bound. That is all my request before this order.
We are not granting any interim. There is no question of granting any interim order.
Now, so far as this Annexure A is concerned, it is without authority of law, and Annexure B, suspension order has been issued without issuing notice. Principles of natural justice has not been complied with, and it is passed under Section 10. Section 10 contemplates lot. The prior notice shall be given to the licensee. Your last may kindly peruse Section 10. Section 10 of Stone Crushers Act.
We'll issue notice and.
Lord. Gross violation of principles of natural justice and no authority to pass such order. Last may kindly appreciate.
Can't conclude that at this stage and amount to granting any relief will be principal relief. On both ways, we are not.
Lord, this Section 10 is for cancellation. There is no power to say.
In the interest of justice, only notice is being issued.
So then you understand what we are saying.
Last may grant a short date so that Lord, let them respond, because running pressure unit has been stalled.
21st February.
Short may take, maybe can.
No short. Wow. Only one thing can be done, that whole day can be kept for you. Next.
Number 26.
Okay.
Okay, be with Lata.
What is it?
Just in this matter, the petitioner was granted Quarry lease, my lords, to Quarry Granite. He has obtained all necessary clearances, my lords, the environment clearance certificate, NOC.
All are same?
No. Yes, my lords, all the three are same.
All three.
All the three are same. They're adjacent, my lords. My lords, he's been granted all the necessary permissions and statutory clearances, my lords. NOC from the Revenue Department, environment clearance certificates. There is an approval of the scheme, my lords. Everything is there. Now, my lords, kindly peruse, my lords, page 94, Annexure J. My lords, very strangely, the principal district and sessions judge, my lords, and the chairman of the District Legal Services Authority, my lords, I fail to understand under what authority she writes, my lords, to the Deputy Commissioner, Chamraj Nagar. My lord, she says the Gomal land is not sufficient in the two villages, adjacent villages. So kindly see, my lord, she says page 106 is the relevant portion. If your lordships, it starts from page 94, my lords. Very, very strange. If the District Legal Services Authority comes into the mining and quarrying area, my lords, I really fail to understand how she even writes such a communication.
I fail to understand how my learned friend has got, my lord, the proceedings that are, my lord, interdepartmental.
It was given to us.
My lord, this is a step.
Kindly see page 106, my
process of
lords.
taking a final decision.
Kindly see 106, my lords.
It is not meant for
therefore,
outside exposure, my lord.
They have given it to us. Otherwise, how will I get it? My lords, therefore, your lordships got in center, my lords. Therefore, page 106.
It's a premature writ petition.
Therefore, considering all these aspects, I feel it necessary, request you to consider the request of the villagers dated so-and-so and to cancel the license issued to the above persons in survey number 159, that is Gomal land of Heggatora village, and survey number 239 of Muttige village, and to preserve the greenery and Gudda. My lords, all these aspects has been considered before grant of environment clearance certificate. It is also requested to reserve all these lands for Gomala land.
On the basis of this, it is.
Basis of this, the task force committee, my lords, I again fail to understand where they get jurisdiction. My lords, kindly see page 123 is the Kannada document. Page, my lords, I will read only the relevant portion of the district task force committee. My lords, page 130.
129.
129, it starts from page 125, my lords. Page 125, subject 5, my lords. They refer, my lords, quarry leases have been sanctioned in Gomal area of Hegatoron, Mithige villages of Chamrajnagara Taluk, Chamrajnagara district. The villagers have filed a complaint in the District Legal Services Authority. Your lordships got, my lords, page 125. May I continue, my lords? Page 125, my lords, is the resolution of the District Task Force Committee. 125, my lords. This is the subject number 5. Quarry leases have been sanctioned in the Gomal area of Hegatora and Muttige villages of Chamrajnagara Taluk. The villagers have filed a complaint in the District Legal Services Authority regarding the inconvenience to public due to the said quarry lease and lack of gomala for the cattle. In respect of the said complaints, the respected principal district and sessions judge herself visited the spot. My lords, are we in deficient of cases, my lords, before the Chamrajnagar court was what I thought. Do we have very less litigation
No,
there?
no.
She visited
My
this
lord,
the
let my
spot
learned friend
and
not
has
exceed
filed a
her
report.
submissions, my lord.
And has filed a report. I thought about it myself. I cannot help if my thought goes that way.
Yeah, yeah.
And has filed a report as follows.
My lord may see.
Kindly see page
129.
128, my lords.
My
Page
lord, page
129.
129.
I'll read it, madam. Please wait.
No,
Page
you please
128.
wait. You don't this thing.
I thought
My
I'm
lord,
the
page
petitioner.
129.
I'm the pet. Why is my learned friend? She'll fail, my lords, in her health if she.
What?
If your health, you don't have to.
No, you
shout.
don't worry about my health. You
I'm
take
very
care of your
concerned
health.
of my
No, don't worry.
Please,
You
please.
take care of your health.
Yeah.
Don't
Please,
worry
please
about
wait
mine.
sometime.
No.
I'm the petitioner. There is no
All
note
right.
here.
You worry about yours. Don't exceed your
128.
limits.
Both of you.
From morning,
My
my
lord, I
lords,
don't understand
don't
this.
know
my
why
lord.
there has to be a
Both
screening.
of you take care of our health also.
They have nothing more but to have negative attitude towards me. I don't understand.
Why is she?
Why are you like that? Exceeding in your jurisdiction, saying that, the district judge and all, that
I do. If the district judge is written like that.
Not within you.
I don't have jurisdiction at all. I'm not a judicial authority here.
Yeah,
Kindly
that's
see
what you
page 128, my lords.
are making.
Can I request you lordships to go to page 128? What the task force committee does, my lords? Read, may I read, my lords? Page 128, bottom. Can I, my lords?
So it is not cancelled so far.
No, but it has been, it is not cancelled so far. But kindly see
That's
the
what I was submitting.
page 129, my lords.
Last
120
sentence.
Can I read page 128 onwards?
Learned,
Reiterating the said rule,
Miss
letter
Vidyu-
of the learned principal.
One second, Miss B.B. Vidyulata. All are identical facts.
Yes. They are queries in the same survey number, my lords. My interim order is only, my lords, not to cancel my quarry lease because this is a manner unknown to law. They have given me environment clearance certificates. They have approved the scheme. My lords, they have given me permission to blast NOC revenue.
You are given notice for cancellation.
Nothing,
No, my lord,
yes.
nothing has happened. This is
Why
only
is she shouting, my lords? I'm the petitioner.
I'm not shouting.
Kindly see, my lords, notices
You're
at
hard of
page.
hearing, I can't do anything.
Annexure K.
Yes.
I will be hard of hearing in a few days.
Yeah.
Page 130 is the notice 5/12/2026, 2024. Annexure K1. Notices have been given.
Here you are challenging?
My lords, notices I'm not really concerned. My lords, I've asked for, kindly see my interim order, my lords. I've asked for, my lords, the authorities are saying they cannot bear the.
Heard learned advocate Ms. B.B. Vidyulata for the petitioner and learned additional government advocate Srimati Nilofer Akbar who appeared upon service of
My lord, may I make one submission?
petition in advance.
My lord, page 129. My lord, the last 3 sentences, in view of the non-availability of Goma land, as per the rules, a decision was taken in a meeting to issue a notice to cancel the lease granted in so-and-so villages and to proceed in accordance with law. My lord, after that, my lord, nothing has happened.
It has happened. It has
My
happened.
lord,
K and K1
these are
has
the proceedings. These are the proceedings, my lord, of the district task force, and it's not communicated.
We really don't approve and outrightly not approve the conduct of the authority who is a judicial authority, in writing such a letter, and your authority is influenced by that letter and is proceeding to cancel the license, therefore we are inclined to grant the relief. Very clear. By filing, what did you write? By filing this petition on Article 226 of the Constitution, direction is prayed for to set aside the proceedings dated 4/11/24 of the District Task Force Committee. It is also prayed to direct the respondents not to cancel the quarry lease granted to the petitioner in quarry lease number 316 without due process of law. Full stop. Figures on record. The communication. Where is that letter?
Page 94, my lords, 94, annexure J.
Figures on record. The communication dated 3/10/24, addressed in great details by the honored chairman of the District Legal Services Authority to the Deputy Commissioner Chamarajanagar. The chairman of the District Legal Services Authority, Chamarajanagar, has proceeded to mention certain facts to write to the authority to take penal action in respect of the quarry land of the petitioner. Penal action of the petitioner in respect of petitioner's apostrophe as quarry land on the ground that it is in the Gomal land.
It is Gomal land.
Gomal land. Full stop. The District Task Force Committee considered the issue on the basis of the said, with the contents of the said letter, and has recommended the cancellation and recommended the action in law against the petitioner, including the cancellation of the license, the cancellation of quarry lease.
Yes.
Full stop. Irrespective of veracity or otherwise of the contents in the contents mentioned in the contents of the aforementioned letter dated 24/1 with 3/10/24, sorry, letter dated 3/10/24, the case turns out to be an instance where the District Task Force Authority has been influenced by District Task Force Authority in its conclusions, is influenced by an authority who has prima facie no business, no concern in the subject matter. Full stop. In that view, notice returnable on 13th March. The respondent shall maintain status quo.
Yes, ma'am.
Obliged.
Let them not ask me to
Respondent
stop quarrying.
Shall not take any precipitated steps against the petitioner and shall not cancel the quarry of the
And they'll not
quarry
prevent us from,
quarry lease of the petitioner on the ground, on the basis of the facts stated.
or stop me from quarrying, my lords. That's, they cannot They need not stop me from querying also, my lords, without cancel it, if they suspend or anything.
Oh,
Malad, no
Simple
precipitative steps is,
So shall be maintained by both the sides.
yes.
We
I'm
will be querying, my lords. We may be permitted to query.
Status for your running. You're running.
They will not issue permits, my lords. Let the previous order only be there, my lords.
What?
Your lordship said, let them not cancel and let them not,
No.
kindly see my interim prayer, my lords. Have just sought for not to cancel the query lease granted or prevent the petitioner from conducting querying.
No precipitative action shall be taken based on the letter dated 3/10/23.
Great.
Yes, obliged.
The other two, only query lease numbers vary, my lords, in the other two petitions.
Numbers will vary.
Yes, my lord.
So separate order in each matter, but query number will.
These number. Grateful.
Only shall not cancel this, shall not take any precipitative, only on the basis of. Only on the basis of the contents of letter dated 3/10/20.
Malad, but that is based on the representation given by the village. No, I understand what's passing through my lord, because once that has been given, I understand. Malad, but in case if,
Any authority goes on interfering in the.
no, I understand. Malad, the very fact may be they must have
Yes.
changed their mind because these proceedings are of 4th November 2024.
The
Thereafter,
highest judicial authority in the district.
my lord, based on the representation of the villagers, my lord, the difficulties that they have put forth, maybe she has done it with good intentions, but the very fact that no further steps have been taken pursuant to the proceedings, my lord, that is what I wanted to make a submission to my lords.
We also want you to maintain your uprightness and integrity, as we would like our officers to do. Both ways. As the authority has no business to write a letter, you are also not supposed to be influenced by it.
No, my lord, maybe, my lord, this is part of the communication. No final order has been taken, is what I was submitting to my lords. In case,
There is a principle in administrative law that an authority supposed to decide under the statute is not expected to be influenced by other authority. This is far more than that. It is vitiated, your action is vitiated. So right or wrong is a different thing, but it is vitiated on this count. That is the whole thing, yes.
Grateful.
This is number 29.
Yes.
Please, my lords, my limited prayer here is to consider my representation, which I have given and produced at Annexure A, that may be considered in a time-bound manner, my lords. That's the only limited prayer, that let them not disturb.
my lord, the representation is dated 31/12/2024. Writ petition is filed on 17/1/2025, my lord.
True, my lord, because of
Given-
urgency, because for the last more than 1 year, I am without
Given
bread,
12.
my lords.
That.
Because since August 2024-23, my query has been stopped, that I am prevented from carrying out query operations for no legal reasons, citing a very flimsy ground that you are directed to carry out querying in terms of Rule 6(2). That's what.
They must be considering, it is a very recent report.
No, of course, let them consider, but my only request is, let them not disturb my querying, my lord. That's why I am well within my rights.
So there is no other prayer, as you rightly said.
Beg your pardon?
There is no other prayer except consideration of representation.
No, in that, I have mentioned that let them not permitting him to carry out uninterpreted querying operations through controlled blasting permissible under newly amended Rule 6(2), effective from 7/3/2023.
Consider
Rule
the,
came to be,
consider the representation permitting him to carry, yes. That is your prayer in the representation.
yes, my lords.
They'll consider.
No, no, we will consider it in accordance with law. And we've hardly had 15 days to look into the
No,
representation.
for considering in accordance with law, whether it is 8 days, 10 days or 10 minutes, doesn't make any difference, my lords. In the first instance, they are not supposed to prevent me from carrying out the query activities. And such submissions, my lords, it is
My lord,
pains us.
what is this, my lord? What submission? This submission, I'm really not able to understand.
Sorry,
The
I'm
moment
today-
I make a submission, you are screaming, take care of your health. I didn't know I had such good well-wishers at the bar.
Since morning,
And,
I'm before my lords, I have heard enough
Must
today.
be having
Sorry,
it
my
here.
lords, I will not argue, maybe posted next week, my lord.
I don't understand this, my lord. I don't understand their attitude. Their mindset is just full of negativity, vengeance.
He'll take Mr. Mahendra to task.
What for, my lord? I don't want anybody.
He's instrumental in raising the temperature.
No, 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 my lord, that doesn't affect me. But what I am submitting to my lord is, this is 3112 and 17-1 is filed. So give us some time, my lord, to
Only
look into
prayer
it.
is to decide the representation. We'll put up matter for 2 weeks to decide.
Yes, yes.
Please,
The only
ma'am.
prayer in this petition filed under Article 226 Constitution is
My lord may keep this pending and call it after 2 weeks.
require the respondent authority, competent authority to decide the representation of the petition dated 31/12/24, which is produced on record of the petition at annex array. Learned paragraph, additional government advocate Srimati Nilofer Akbar is justified, who appears upon service of copy of the petition in advance, is justified in submitting that the representation is very recent and the respondent for shall take appropriate decision in accordance with law within period of 4 weeks, 6 weeks, 6 weeks from today.
Before 15th February, my lords.
Why?
Because thereafterwards, I will not be available in the court for some time, my lords, for personal reasons.
Very.
Before earlier to 13th February, my lords.
On or before 15th February.
15th must be Saturday. 15th must be Saturday.
15th is on or 15th February, Sunday, Saturday.
Any date here and there, my.
This court does not express any opinion on
My
this.
lord is disposing it on. Let him.
Disposing of. So that you can file press petition after you come back.
Please, my lords.
This court does not, has not gone into the merits of the case of the petition, nor has expressed anything on the merits since the competent authority, this one for units, is required to go into the grievance of the petitioner and decide the representation.
But my lord has granted me time till 15th February.
Writ appeal matters, this is number 30, Nanda Kishore.
Appear for the appellant.
For the respondent number 1, my lord. in this.
My lords, the appellant is the Agricultural Produce Market Committee, which is a statutory authority. And respondent number 1 is an allottee and a commission agent operating within Bangalore city. He has obtained license from us and he's operating as a commission agent. He will make the buyer and seller come together and he is supposed to collect his commission for that work. And under the act, my lords, he is supposed to ensure prompt payment to the agriculturists then and there. If he fails to make payment to them then and there under section 78A, read with section 118A of the act, he is liable for prosecution. Now, admittedly, my lords, the respondent number 1 being a commission agent and being an allottee of one of our properties, he became a defaulter and he failed to pay 2,55,000 rupees to the concerned farmers or agriculturists. For that, criminal prosecution was initiated against him and it is still pending in CC 26218 of 2019 under the criminal law because he has committed an offense. And he has admitted in the writ petition that he has not paid the agriculturists. Second ground of default, Your Honor, is that he has failed to pay 6,58,723, which was arrears of leave and license payable to us because he had obtained an allotment from us of a shop in the market yard. On both counts, he is an admitted defaulter. Now, we passed orders cancelling his allotment and forfeiting the property, and also initiating criminal action against him. And the property was forfeited. Against the same, he preferred a writ appeal, statutory appeal to the director. That also was rejected. Even at that stage, he did not pay the defaulting amounts. Finally, he filed a writ petition before this honorable court, before the learned single judge. At that stage, my lords, whilst granting interim relief, he complied with the interim direction that he pay the defaulted or the arrears amounts. So after a lapse of 4 years, he finally paid the sum of around 2.5 lakhs payable to the agriculturists, another sum of around 6.5 lakhs payable to the market.
It was the amount towards what?
2.5 lakhs, 2,55,000
Towards
agriculturist dues, farmers dues.
farmers' dues.
Farmers dues, and 6,58,723 towards leave and license payable to the market committee. He paid it only subsequent to obtaining interim orders by this honorable learned single judge of the Honorable High Court. Then, my lords, the writ petition was opposed by us. And in the meanwhile, a learned single judge of the Honorable High Court has held, if a person is a defaulter under the Act and has failed to pay the agricultures and leave and license payments, he cannot be shown any mercy. In fact, the APMC should very strictly act against such defaulters. Honorable Justice Suraj Govindraj has passed a decision. And in fact, he has directed the APMCs to take action against such persons. Now, my lords, the learned single judge has held, even though he is a defaulter, since he has paid the amounts pursuant to interim directions, his application for conversion from leave and license to lease cum sale should be considered. Our problem is he is a defaulter and he is being given a bonus in spite of being a defaulter, when in fact, criminal prosecution is pending against him. And that approach would be contrary to the ruling of the learned single judge in another matter. Kindly see, my lords, page 21 of the impugned order. From page 20, I will read.
May I make a submission, Madam?
One second.
May I read from para 5, my lords? Page 20, para 5 of the impugned order.
Which penal interest he has paid?
He has paid, that is under the Act, he has to pay. He has to pay, he has paid. But now he amounts to a defaulter, and under Rule 7, he cannot be.
That appeal is pending.
No, my lords, criminal case is pending.
Criminal case.
Criminal case is pending for prosecution. It's a little bit like, my lords.
This leave and license can be converted into lease agreement under some rule.
Yes, my lords.
Let us.
Rule 12, sub-rule 2 of the 2004 allotment rules.
Hmm. 342 page.
What was the prayer in the petition?
My lords, in the writ petition, the prayer was to quash the order of the appellate authority and also the resolution passed by us, and to consider his representation dated 18/5/2020.
What was the representation? It is there at annexure.
Yes, annexure F.
Page?
Page 867.
87.
67.
67.
The typed translated version at page 69. And the operative portion at page 71, relevant part at page 71.
So it was for regrant of license.
For regrant.
Regrant of leave and license.
Of leave and license.
So in any case.
In any case, he has not sought conversion at all.
Right. That's right.
That was not his prayer.
May I submit my?
And doubly problematic because he is a admitted defaulter. who should be shown no grace. It's all public property. Being an admitted defaulter for years together, he doesn't pay the amounts due.
So we are for original petition.
Criminal petition is pending,
You
my
are for
lord.
original petition.
Yes.
Petitioner, my lord.
So was it your submission before learned single judge that convert my live-in license to lease agreement?
Please, my lord, my prayer is, my lord, in 2020, forfeiture order has to be quashed, my lord. Later, my lord, 2025, when it came for the final hearing, my lord, that time 55 months has been completed, my lord. That time they can't renew the license, my lord. Meanwhile, my lord, they can convert it to, as per rule 12 class 2, my lord, they have to convert the lease come sale, my lord. Since I was in a lease, leave and license.
May I just explain?
You are supposed to, the petitioner is entitled as of right to get this converted?
No, not of
No.
right.
I'm-
It's discretionary
I'm
order
the conversion,
under
my lord.
rule 12 sub rule 2. The word used is may. The word used is may. It's a discretionary order under rule 12 sub rule 2.
My submit facts of the case, my lord. My learned friend is confusing the court, my lord, saying
No,
that
no, I'm
I
not
have paid the
confusing the court.
interest amount after the impugned order, my lord. I have paid the farmer's dues in 2020, my lord, before passing the impugned order, my lord. That has been passed in 14/5/2020.
Kindly see,
I
my
have
lords,
paid the entire
to make
amount that
things a
has
bit
been
clearer,
annexed
kindly
from
see
credit.
the order passed by the learned
Yes,
single
sir.
judge in a connected matter. Identical circumstances.
That is, both cases are different, my lord.
Right, my learned friend had appeared in that case.
That is
This,
not reached.
The
penalty,
learned
my
single
lord,
judge has come down heavily on
Yes, my
such
lord.
approach of the traders, who has duped the farmer also, and he has duped the APMC also.
My
Now
lord,
he
may
wants
kindly
confessional
take,
consideration.
I request to take page number 51, my lord. 51, my lord. I have paid entire amount, my lord, on 4/5/2020.
After 4
Order
years.
has been passed forfeiture, my lord, that is 14/5/2020, my lord. After 10 days.
In representation, this prayer is there.
No, my lords. This prayer for conversion is not there.
My representation in 2020, my lord, that period, my lord, I am on leave and license basis, my lord. My allotment is 2018. 55 months not completed. Hence, I have not made application for the converting to lease come sale, my lord. 2024, I am eligible for the leave, converting to lease come sale, my lord. Since my allotment in the original market in the Yeshwanthpur market at my lord 2003. After that, my lord, they have shifted renewing of the license in the 2018. They have shifted me to Dasanpura market at my lord. In 2018 and 2020, my lord, I have paid the entire farmer's dues, my lord, on 4/5/2020, which is not considered by the second respondent, my lord, has passed this order.
Heard learned advocate Mr.
Nandakishore.
Kishore for the appellant, from a learned additional government advocate. Mr. Harish.
For respondent
for the
number.
respondent state and
Three.
learned advocate Miss
Shilpa Rani.
so and so for the original petitioner, respondent hearing. The appeal arises against judgment and order dated 19th April 24 of learned single judge, whereby the petition is allowed and following operative directions are issued. So quote from page 21, 2 and 3 bracketed portion, 2, 3, 4. 2, 3, 4 and 5, 2 to 5. In the facts of the case, the appeal is admitted. Paragraph, as far as the prayer for interim leave is concerned, the court is inclined to grant interim leave, at least for 2 reasons. Firstly, the direction of learned single judge granting liberty to petitioner to file application under Rule 12(2) of allotment of property in market yard rules 2004, and to direct the respondent to consider the said application. Clearly. 2 reasons, inasmuch as while issuing direction, granting liberty to petitioner to file application under Rule 212(2) of the aforesaid rules, 2004, and further directing the respondent to consider the said application, learn a single judge has travelled beyond the prayers made in the original petition. In that sense, it could be submitted prima facie that the direction could not have been issued. Secondly, on reading of Rule 12 into bracket 2, on bare reading of Rule 12 into bracket 2, it signifies that the said rule grants said rule vest in the authority a discretion to accept the request of a person, of a market functionary, to convert the leave and license into lease cum sale agreement. But the said cannot be claimed. But the such conversion cannot be claimed as of right. Full stop. It has to be observed that while considering such application by the market functionary, a host of consideration may weigh with the market committee authority. Thirdly, when the criminal case is pending, it may be a relevant consideration. It could have been a relevant consideration for the market committee to refuse the request.
My lord, until unless conviction order is put, my lord, he can't cancel my license.
Even
my
if
lord.
it was made, even if it was made under Rule 12(2) of the rules.
There is, in the act, my lord, there is nowhere is mentioned, my lord, if fail to pay the farmer's fees, my lord, cancel my license. Only if suspend for the 1 year, my lord, as per rules, my lord. Only 1 year he can suspend.
Rule 7, he is the defaulter.
And it has been renewed. My license is valid up to 2028, my lord. That order has been considered by the learners.
What is the stage
As
of
per
the
the
criminal
rules,
case?
my lord.
Criminal case, my lords,
For the
charge
criminal
sheet
case, we
has been
can't-
filed. It is undergoing trial. He has virtually admitted that he has not paid the amount. The only thing is conviction is pending, that is all.
The appeal shall be listed for final hearing on 9th April.
Yes,
There's a delay, my lord. There's delay in filing the appeal.
the 25 days delay because they
Delay
had,
is gone down.
Yes.
Delay is gone down.
the matter could be
My
stayed.
lord,
For,
my lord, in
ordinary
this case,
order.
my lord, since from several years, my shop is forfeited, I have entire amount with penalty, I have paid it, my lord.
This
With
application
penalty, I have paid, my lord.
Taking condonation delay of how many? 25?
25 days.
The accompanying affidavit explains the passage of time leading to delay to make out sufficient cause. Delay is condoned, application left. Then this order.
Stay of the impugned order. My lords.
My lord,
The impugned order shall remain state.
my lord, in this case, my lord, entire amount with penalty, I have paid it. It is.
My lord, this is a case where it's like a thief
My amount.
after
my lord,
stealing something,
without
then
shop.
returning the money.
Directions in Roman 3. Shall remain state.
Well, operation.
Directions in paragraph 9, Roman small 3 shall remain state during the pendency of.
Much obliged.
Notice of admission of will shall go to respondent.
Number 31, Mr. Sharat Kumar.
Appearing on behalf of the respondent number 1, my lord.
Lord, today they have, my lord, given the copy of the statement of objections, my lord, and they have said it will be filed in the registry.
I will be filing my statement of objections to their stay application in the registry today, my lord. The matter may be called in on any day in the first week of February, my lord. I request for a date in the first week of February, my lord.
Is only remanded.
Yes, my lord.
Please,
Lord, in
please. That is very respectful.
the last date of hearing, my lord, the senior counsel argued the matter and they took time And now they are saying.
We have,
my lord,
we
are
have served a
going counsel,
copy
my
of
lord,
our, we have served a copy of our objections on the,
Today they
on my
have
learned
served
friend, my lord. I'll be filing it in the counter as well, my lord.
Learned respondent wants to file counter affidavit, which may be filed in the registry, put upon
First week of February, my lord. Any day.
week of February, 11th February.
Grateful.
So 32 is urgent. Seal number 33, T A B Gangadharappa.
Appear for the appellants. First appellant is the commissioner of the city corporation. Second appellant is the assistant executive engineer working in the corporation. Now, the corporation has got a private bus stand in Shumaga. And by issuing tender, the work of maintenance and cleanliness, etc., was entrusted to third party, who is respondent number 3. It is virtually an outsourcing of the work by the corporation through the agency of the third respondent. As far as the persons employed are found to be working in the private bus stand for the maintenance is concerned, corporation or the corporation officers have no control. It is the responsibility of the contractor, who is third respondent, who has to pay the salaries, minimum wages, etc., etc. Now, the complaint is filed by the labor inspector, stating that during the course of his visit, he found that certain persons have not been paid minimum wages as required and issued as per the notification issued by the government. Without even issuing notice, an order came to be passed by the deputy labor officer, deputy labor commissioner, respondent number 2, fixing the responsibility on the commissioner and executive engineer of the corporation, and also awarded 10% penalty on the non-payment of the amount. My submission before the learned single judge is there is no privity of contract. We do not know who are all the persons who are engaged, under what circumstances and all that. So far as the corporation is concerned, it is only concerned with the maintenance as required under the provisions of the Act, and it has to pay the regularly the contractual amount for every month maintenance. As far as payment of salary, wages, etc. is concerned, it is not the concern of the corporation or any of the officers.
You have got license under the Contract Abolition Act?
No, I have no license at all.
Then how do you?
No, it has been entrusted to the contractor by issuing tender, calling for tender. Contractors will be.
You have the license, the contractor.
Yes.
Contract labor, Regulation and Abolition Act, page
License.
21, paragraph 10 may kindly.
The license under the act is to be obtained by the contract.
By the contractor, not by the corporation or its.
Page 21, my lord, the paragraph 10, the provision of 21(4) has been extracted, my lord. The primary obligation is on the contractor,
Yes.
principal employer.
It is anything is there to show that it is an admitted kind of fact that you are engaging the contractor.
There is nothing on record. Nothing has been placed even before the deputy labor commissioner to show that there has been any privity of contract.
So it is your case that you are the principal employer and they are not your employees. That is your case. So what did you say? How do you show that?
Annexure A may kindly be looked into, page 33. That is the agreement entered into between the corporation and the contractor. Please go to page 34. Item number 12, condition number 12. The service.
Probably even then the liability will to pay the minimum. Under which section? Liability or responsibility?
Section 20. No, contract labor side only.
The contractors.
21, subclass 4, my lord.
Minimum wages.
Contract labor, regulation and abolition, that has been extracted at page 21 of the order.
So you are not an outsider. Look at the provision.
so far as the commissioner of the corporation and assistant executive engineers are concerned, they are the employees of the government and they have been deputed to work in the corporation. We have no control. Corporation has also no control about the person who employ those persons. We have no control at all. We have only got control over the contractor for payment of the agreed amount every month. And it is his responsibility to maintain. And that is also one of the terms and conditions of the contract. There is no privity contract. We have no control about the employees employed by him.
Probably there is a judgment of the Gujarat High Court where I was a party. The view is taken that the principal employer is equally responsible.
Please, my lord, they have to pay and recover, my lord, from the contractor. That is the provision under 21(4). That is extracted in paragraph 10 of the judgment, my lord.
Which provision, section?
Section 21, subclass 4.
21(4).
Please, my lord.
Yes.
In case of a contractor fails to make payment of wages within the prescribed period or make short payment, then the principal employer shall be liable to make payment of wages in full or the unpaid balance due, as the case may be, to the contract labor employed by the contractor, and recover the amount so paid from the contractor, either by deduction from any amount payable to the contractor under any contract or as a debt payable by the contractor. The operative portion says paragraph 12.
Where is the order of the payment of wages authority?
Order of the authority is at Annexure B. English version is at page
53, translated version.
Page 53.
53 is the translated version.
Page 53. No notice was issued to me. I have not been served with any notice in connection with the complaint stated to have been filed by the labor inspector. Ex parte order came to be passed. Kindly go to page 56. Page 56. Last paragraph in that page. Opposing the application made by the applicant, since respondents have not filed any objection, and as such it is held that organization has not paid minimum wages and less wages had been paid for 6 months from
But who appears for the contract?
Notice has to be issued, my lord. Respond number 3. Notice may have to go to.
Notice to respond 3. Notice to respondent 3.
Please.
Returnable on. Notice to respondents.
respondent.
Returnable on 17th March.
There was an interim order during the pendency of the writ petition. That may kindly be. Otherwise, the authority will enforce the payment.
The 3,55,000, what is that amount?
3,55,000.
3,50,000.
Please.
Learned advocate, learned government advocate, various ways, accepts notice on behalf of the respondent state.
That's pay and recover, my lord, basic.
No, I cannot recover from the party.
Pay and recover is the order.
There is no relationship. I am not even the principal employer. I am not even the principal employer. I have no privity of contract. There is no relationship.
Who are you?
I am only commissioner of the corporation, which has established the bus stand. Nothing more than that. And a tender was invited.
You are a corporation.
I am a corporation.
Principal employer.
There is no principal employment. I have not employed any one of the persons. The work is entrusted to the contractor.
You are employed through contractor, therefore you are.
It is only through the agency of the contractor.
This plan to grant stay.
Otherwise,
you may have to pay or you deposit.
I have not committed any default and no notice was issued to me. Principles of natural justice, minimum is, I should have been provided with a notice. I will have made the submission before the authority.
Deposit the amount.
I am seeking, there was an interim order during the pendency of the writ petition. It will be very difficult and it will be even impossible to recover from the third respondent. It is his responsibility.
3,55,000 for a corporation is not a big amount.
No, I am not on the question of the quantum of
Without
the amount.
prejudice to rights and contention of yours, you can deposit it. And we'll grant.
Even assuming that I will have to deposit, what happens is ultimately I succeed, I will not be in a position to recover the amount.
No, deposit here. With the registry of this court.
That can be done, that can be done, that can be done. That can be done. Subject to deposit.
Where you are showing that order of the, it is only 3,50,000
Please, my lord.
with interest, no.
No, in fact, what the authority has held it, the salary for the period of 6 months has not been paid.
Page 58, my lord.
That has been calculated. Totally it comes to 3,05,220.
55,220. Page 58.
50,000. Difference of minimum wages is
Learned advocate for the appellant, praise for stay. Full stop. Stay of the judgment and order. The competent authority under the Minimum Wages Act, Hassan Region Hassan, has held that the difference of minimum wages and compensation totally rupees 3,55,220 is payable by the responsible parties, including the appellant hearing. Full stop. On condition that the appellant deposits with this court the aforesaid amount of rupees, registry of this court, the aforesaid amount of 355,220 within a period of 2 weeks from today.
Please.
The judgment and order of law and a single judge shall remain state till the next date.
May I make a submission, my lords?
Today, lot of matters are left out.
Yes. Serial number 50, my lords, may be
50.
listed
50.
next Thursday in view of urgency, my lords.
51,
50.
50.
Yes, next Thursday, my lords.
All right, next Thursday.
Please, my lord.
Serial number 45, ma'am. Serial number 45.
40.
Date could be fixed, my lord, any date next week, my lord.
What is that PIL?
But this PL is regarding encroachment of the forest land by the respondent number 11. Action, my lord, direction has been already issued to the government to
17th of February.
please.
I love 53. I want 53.
One by one, yes. 46.
We have produced all the documents.
18th February. 18th February.
Lordship.
Seven.
Since there are people are suffering. Yes. My lordship, item number 53. Item number 53.
47, Your Lordship. The government advocate had to file an affidavit. Affidavit copy is ready. It's only written the nature of mandamus sought. Written the nature of mandamus to consider my application, Your Lordships. They're supposed to file an affidavit. Affidavit copy is ready, Your Lordship. Day after tomorrow on Monday, because it's, the reason is I filed it's 2018 application, Your Lordship, because they've come to consideration saying that it's not a forest land. Only to consider, Your Lordship, my application is pending since 2018.
Lordships heard the matter last occasion. Government advocate told they'll file the affidavit. Copy of the affidavit is ready with them. But they told when matter reaches, they'll serve the copy. Till now, they've not served the copy. I'm just saying only the matter. Last occasion also, they told they'll serve the copy, Your Lordship. Only to consider my application since 2018 and
We'll do that, my lord. We'll serve the copy.
since 2018, Monday, Your Lordships, because I filed, it's almost.
Monday they will serve the copy. You
Yes.
don't serve before Monday.
Lordship, sir, I'm just requesting matter to be considered in view of the submission, because in 2018, my application is dated, it's in Patal and 19/12/2018, I filed application, written the nature of mandamus, Your Lordships.
11th February.
My Lordship, in the item number 53, I'm here from Delhi. So a physical hearing, I may be given on the 27th of this month.
You are from Delhi. You are, yesterday also you were there.
Yes, sir, 2 days back.
2 days.
Yes.
So you went back to Delhi and come back,
No. Actually, I postponed the flight.
postponed
Yes.
for this matter.
No, for other reasons also, along with this matter.
So what is the matter?
Matter is contempt being done by the NCLT judges, NCLT judges and the CCH 92 by violating the order of this honorable court. And that is hampering my interest also because my CIRP cost and fees is not being paid.
All right. Since you are party in person,
Yes, I am parting.
27.
27. Thank you, Malak.
Serial number 35, my lords, the contempt will be listed on the 29th. This can also be taken up along with that and the connected matter on the 29th.
29.
Serial number
Shall I
40.
pass me number, ma'am? The contempt and the writ appeal numbers?
My lord,
Today it's not listed.
One matter is listed today, member, the other matter is not. I'll pass on the number.
Lord, serial number 43, it is challenged by the party in person regarding the impediment of the party in a writ petition in a BBM matter, madam. It has been rejected by the single judge, my lord. Now she has come up with this application. There is no proper permission also.
There is a
She is not necessary party. It is a statutory body is taking action against the
delay.
alleged illegal construction, madam.
There is a delay of 59 days.
Yes, my lord.
So we'll issue notice.
She has not obtained any permission. She is not required to implement the BBMP matters.
We'll issue
The
notice.
statutory body is taking action, my lord.
We'll issue notice in delay. Notice returnable on 24th March.
And the appellant, my lord.
So you are delayed by 59 days.
Just, that I was thinking it is 3 months' time.
Notice is issued.
I represent fourth
was-
respondent, my lord. He is the owner of the building.
So we'll keep it on some other day.
Can you give Saturday, please? Saturday.
Saturday, 3rd February. 3rd February.
Serial number 92, my lord. State appeal is there, my lord. There is some serial number 92. State appeal, my lord. There's an office objection. We have given a submission, my lord, regarding the translation to a gazette order that may be dispensed.
92.
92, my lord. The state appeal, my lord.
Office objections regarding the translation is dispensed with. There shall be notice in the delay application.
Grateful.
Returnable on
Lord, serial number 93, my lord.
6th March.
Grateful.
Sorry, my lord, serial number 93, my lord.
Serial number 44, my lord. This is a PIL, my lord. Since September last year, the state is supposed to have filed an affidavit as to the status of the caste certificates, my lord. Till date, it's not been filed.
Caste went.
Fake
Caste certificate went.
Yes, my lord.
Caste certificate, I appeal for the respondent, my lord. My lord, we have communicated to the government.
Yes.
My lord, the government.
They have already issued notices to the fake.
Everything, pleadings are complete, my lord. Since September, they're supposed to have filed an affidavit. They have not filed till date, my lord. Even on the previous date, the learned councils explained
14th March.
my lord, an earlier date may kindly be fixed, my lord. Any date in February.
14
also is
date
fine,
would be
my lord.
idle, my lord. Even I will summon the records from the concerned officials and I place it before my lords.
The same can at least be noted, my lord, because every time that is a submission being
It
made,
will-
my lord.
We are keeping on a day when it reaches, yes.
My lords, here
Still-
55 for the petitioners here,
Please.
for the petition, serial number 55, my lords. There's an urgency in the matter, my lords. May I kindly have it on next week, 30th, my lords. They're the teachers who teach the disabled students, my lords.
Student.
I
It is
mean,
contempt.
Contempt, yes, ma'am.
Contempt.
Contempt.
What is the contempt?
My lords, here the teachers who have been recruited and there was a change in the government notification, my lords, where the qualifications have been changed from BA to D8, my lords. So hence, I request at least on 30th or 6th of Feb, my lords.
20th February.
My lords, 13th of Feb, my lords. I request, my lords,
Why?
13th of Feb.
Why?
My lords, here on 20th, the senior counsel will not be available, my lords. I request on 13th of Feb, my lords.
14th.
Please, my lords.
Seal number 42, my lord. Seal number 42. Examination matter, my lord. 31st is the last date for payment of examination fees without fine. It will be taken up on 29th, my lord.
20.
Serial number 71 by this.